Court nerds, time to get served. I had a laugh. I laughed about that about 30 times today. 30 different times today. How we doing, people? Are we ready for a good show or what? How we doing? We got fun. We have tpOMG madness tonight. Yes, we have voicemails with the word cuckold involved. Problem, good news, bad news. Bad news first. Bad news, it just cut out really and everyone in the chat who hangs out with me during the day can concur. We were rolling right along and then she cut it. Good news, what we got is phenomenal. So let's warm up first. Let's have some of our favorites. Let's go with Judge Dad. Let's go with Webster. Let's have some fun first, and then we will get to the goodness as everybody trickles in. So let's rock and roll. Oh, you liking the new digs? I kind of don't like it. I'm probably going to ditch them, but I'm just checking it out. Let's rock and roll.
Okay, we have one more waiting at the jail. Once they get them up, we'll call that one. Let's see how fast they.
Come on, Simpson, get on with it. Killing me, Simpson. There we go, baby.
Court does. You good? Okay. Court does call the case of the People State of Michigan versus Benjamin Detlefs.
Good morning, Your Honor. Elizabeth Andery, Assistant Prosecuting Attorney on behalf of people.
Sorry, Judge Mike Gaddy, Assistant Public Defender on behalf of Mr. Detlefs, who is present via Zoom. State your name, Mr. Detlefs.
Good morning, Your Honor. Good morning, everybody. My name is Benjamin Detlefs, for the record.
Okay. I have received the review report indicating that the defendant is still at this time incompetent to stand trial.
That is, we have received it too, Judge. We would stipulate to its entry.
So would the people, Your Honor.
All right. Defendant at this time, and I need an additional order, but I don't, would find that at this time, the defendant is still incompetent to stand trial for the reasons as stated in the report. I will set a new review date for June 22nd.
Your Honor.
June 22nd, 2023, 9 a.m. or as your Zoom invite indicates. Yes, sir.
May I have a breakout room with Mr. Gotti first, please?
I think Mr. Gaddy will come over and see you at some point, okay?
No, I think that I didn't get a chance to talk to him this morning before we went into court. I'd really like to talk to him before we go forward because I was hoping I could get released on bond.
I'm not going to do that. So I don't know any conversation that you're going to have with Mr. Gaddy that's going to persuade me to do that at this time, sir.
$10,000, Your Honor.
Your Honor, I did have a chance to meet with Mr. Detlefs yesterday. We did discuss the matter. If the court wishes to entertain a bond argument, I'm certainly prepared to make it.
Please, Your Honor.
Mr. Gaddy.
I'm sorry, Judge?
I'll let you go ahead, Mr. Gaddy, with the
Okay,
bond argument.
Your Honor, I have had a chance to speak with Mr. Detlefs. This is a situation where he was found incompetent. I don't think there's been any remedial steps taken. There was a review. He is currently on I believe, an alternative treatment order from the probate court to receive an injection of his medication once per month. It is, Mr. Detlefs is confident that if he is released, he could find a suitable living arrangement and would wear a tether. I would ask the court to consider that, or to release him to an approved treatment program if one can be found. But I'd ask, I believe he wishes to ask the court. I believe it's his most sincere belief that he could find a place to live.
All right. I don't need a response from the people. I will just indicate I'm denying defendant's bond motion at this time. I will reconsider it should you find alternative placement for him and a suitable place that the defendant can reside pending this matter. Then the court would reconsider that decision. But at this time, the motion for bond reduction is denied.
Your Honor, I have multiple places I can mention right now, if you have a minute. Like Air Ridge Hospital in Ohio, Brighton Recovery Hospital, Ascension. They're all hospitals for dual diagnosis if you have mental illness as well as.
Then, sir.
Yeah.
You're gonna have to let your attorney do their job. If you mention that to your attorney and they can indicate to me that that is where you would go, then the court will reconsider its decision. I'm not gonna do that by you giving me a list of places. It's not gonna happen.
I wanted to do a breakout room because I asked him to talk to you about this morning.
He loves breakout rooms.
And he didn't even.
Okay, and he has.
No, he didn't.
So okay, I'm not gonna argue with you, Mr. Detlefs. I'm just gonna tell you, I have set the hearing. Mr. Gaddy will be over to see you.
This is cruel and
You can discuss it. He knows how to get, after your discussion, he knows how to get in contact with both the prosecutor's office and the court regarding trying to work something out. But at this time, I'm not gonna have it happen here.
I'm disabled with schizophrenia and this is cruel.
Bond will continue. The motion for bond reduction is denied. Thank you. That's it. Okay, we will be back at 11 o'clock or thereabouts to continue this.
I'm good. How are you?
Good. Ms. Lofton, how are you?
Good, thank you. How are you?
Good. Okay, fine. We're ready to call this case now. This is Leon Mims Jr. versus A.
All right, before I get into this one, in the chat, someone tell me, why do you think I recorded this? There's many reasons why I may have recorded this. The case has nothing to do with it.
AG Management, case number 22-1587. Your appearances for the record, please.
Angelina Thomas Scruggs, P62593, on behalf of Leon Mims, who appears via Zoom.
Paulette Michelle Lofton on behalf of the defendant, AG Management.
All right. And Mr. Mims, can you hear us? Apparently
I'm
not.
texting. Maybe.
Let's give him a minute so he can fully participate.
Okay. let's see.
Not his kitchen.
There he is. Connecting.
Hello.
Mr. Mims, how are you doing?
I'm good, and you, sir? Sorry about that. I'm with my children right now. They're on spring break.
That's okay. Oh, spring break time. You mean they're not off in Florida?
You know, we go to Florida every spring break, but we're going to stay home and save some money this time around with our 4-month-old.
Good for you. You're 4-month-old. Lovely. All right. Thank you for tuning in. If you want to put on your video, that's fine too, but you don't have to. All right. So tell me where this case stands now, please.
Yes, Your Honor. The last time we were here, I did not have a dollar amount. I spoke with my client, went through everything that Ms. Scruggs provided as well as what we had on file. When the case was filed, the affidavit and claim that was filed by Mr. Mims, the amount of money claimed was $825. He filed it as a small claims and then I removed it. The complaint was never amended. We are willing to refund $475.
Jeff. It
That's
hasn't
correct,
come-
Your Honor. Mr.
hasn't come
Mims
yet.
did file the case in pro per. He went to a mediation and a few hearings, and then he obtained an attorney. I believe that complaint that he filed was the form that asked for a dollar amount and then any and other all reasonable costs. I came on to the case sometime last year. I want to say the middle of last year. And then according to my conversations with counsel as well as with Mr. Mims and research of the law, we were able to discover that, the notice that money was outstanding was past the 30 days. Yes, he did ask for originally $875, but that was 17 months ago, Judge.
Smoochie.
Before he hired an attorney, he was willing to just settle for
Tupac.
that.
What's up, people?
My
Is
reading
this-
of the
Is
law,
this about the security deposit? Excuse me.
I'm sorry, this is the security deposit, Judge.
That's what I thought. And what was his security deposit?
His
What's the-
security deposit was $850.
I think it was $825. That's what it says on his filing.
Okay. All right.
Mr. Mims, was it $825 or $850?
To be honest, if I file 825, it must be 825. It's been so long ago. It was 825 or 850. It was one of the other.
Okay, so we could probably get that number, but Mr. Mims would be willing to. My understanding of the law is he'd be entitled to 2 times the amount since the response from AG was late. He's willing to settle for the deposit and then maybe just half, and then waive attorney's fees, which I think he'd probably also be entitled to. I can tell you that just looking at this from a very bare bones type of thing, I could say that I'm probably, I'd claim 12 hours. I'm sure that I have more, but if attorney fees were granted, I'd be asking for 12 hours. They're willing to waive that. I'm willing to have that waived. It's been 17 months, Judge. I do have a video that I could show as far as what the place looked like, before he turned it back over to AG. I don't think it's unreasonable for him to get his security deposit when the delay has been, 17 months. That's a long time when he was a tenant there and paid rent on time every month. It's not like he was somebody who didn't pay rent. And there's correspondence from the other side saying, just patch, don't paint. And then they charge him for scraping and painting. There's correspondence that's charging him for, a dingy shower floor when, he was there for 5 years. It's not that they didn't clean it. It's just that it's plastic and, things break down over time. So I think it's reasonable for security in at least half of what, the double. So we'd be looking at, if it's 825, what is that? 1250? 12. I didn't do math. I'm sorry. I went to law school, but
Ms.
they'd be
Walker,
willing.
Carpet cleaning, which is listed in the lease that was signed by Mr. Mims for $120. A cleaning fee, which is also in the lease, which Mr. Mims signed for $350. And then damages that they assessed in the amount of $1,398. So the security deposit resolution lists that the total charges are $2,147.71 and lists that the security deposit that was retained was $825. Based on our conversation at the last hearing and Ms. Scruggs' argument that anyone that lives in a property for that many years, that carpet's going to need to either be cleaned or replaced, as well as cleaned. You obviously have to clean a unit. So I told my client that that is probably not something, if we proceeded to trial, that the court would award. So that is why they removed it from the security deposit and essentially are foregoing the damages that they believed were caused to the property and willing to return the $475.
And what damages are you talking about there?
There are a litany of them. Let me pull up.
I can pull the list up on Zoom and share the screen, Judge, if you want.
Sure. That would be fine. I have it, but it's not, I don't have it on my computer. So if you
Yeah,
have,
screen sharing would be great, thanks.
Okay, so now,
Also, Ms. Scruggs, I also heard her mention that they said that I had rental rearages. I had no rental
I
rearages.
know
yeah.
that. I understand. Okay, so bear with me because, you know, law school, not, okay, what can you see? Okay, you can see my OneDrive, which is not what I want you to see. So let me stop sharing and open up what I really do need you to see. Yeah. Don't you just love technology?
Sometimes, sometimes not.
Sometimes it's just is what it is. Okay, so that's that. And if I go here, down here, this is okay. So let me. You had an itemized, didn't
Get
you?
glasses for Christ's sake.
All right. So
I'm trying to find it.
now it's just a matter of which one of these tabs is in. All right.
Hold up if that.
Do you?
Yeah.
If you have it, fine, because I've got the video queued to play naturally,
Okay.
but and I've got the timestamp on the envelope that shows
Heck of the life
Yeah.
comes
when it
with
was posted in the mail, which was
It's under
30 days
chaos.
after, more than 30 after he moved out. So
Well, and my client alleges that he moved out on 1/4 and then the timestamp on the letter was mailed 2/3.
okay, timestamp on this
Look at
letter
me, look
is
at me.
2/16, and I've got
The one I have is
stamp.
2/3.
Let me see here.
No, they sent that letter to me about February 16th. We got the original letter as well.
Yeah, I got it on there. So
Yeah, the
you want me to
timestamp
share?
on here.
Yeah, you want me to share it? Lord, how do I get back to the? All right, you're there.
Also, Mrs. Lofton, for
And
clarification,
you know,
uh,
just a minute, Mr. Mims, I want to cut to the chase here. Even if you don't share it, Ms. Thomas Scruggs, can you tell me what it says for assessed damages? Just tell me what it says.
It's
I
a
have
thing.
it.
Oh, it's
Okay, so bathroom 1, remove sticker on shower door. I understand that that Mr. Mims is alleging that this is a sticker that was there when he moved in or when it was replaced. That was
it
$8.
is.
I will forego the $8. Bedroom 1, scrape, patch, paint walls, $295. Bedroom 2, there was a damaged door. They had to replace damaged door, $205. Kitchen, wall, ceiling, scrape, patch, paint walls, $275. Kitchen, there was also damaged blinds that had to be replaced, $35. Living room, walls, baseboards, and it looks like a heat register that had some sort of coloring on it. Scrape, patch, paint walls, $350. The hall, the walls, scrape, patch, paint walls, $215.
What was the damage to the door? Do you know?
There is.
In the second bedroom?
Oh, now I need Excedrin. I have a headache now.
I can go through the pictures.
Oh
and-
gosh.
At this, and then I'd be ready to share the video so you could actually see, because they did put a number of pictures there, but the video will show you exactly what these bedrooms and whatnots look like. And then there's an email from AG that specifically tells him not to paint, but to patch.
Okay, I have the photos pulled up. I'm just locating the picture of the bedroom door here. Okay, bathroom.
Who even cares about the case? Come on. That was great. All right, let's go. I told you. I told you. Come on. And then the best is when she's doing all the faces, and then the wife walks by again. Like, really? He's in court. She really needs to get her grapes while she's watching Netflix. She's watching Stranger Things, binging on Stranger Things, eating grapes. Can't. Oh God. Here we go. Let's have some fun, guys. I love it being in here with you. This is the best. Oh, God, that was Attorney Scruggs. Oh, she is wonderful. Okay. Okay, so what happened here is I only caught a little bit, but I caught the good part, and then I ended up getting something even better because I had it on autoplay, and it went to, I think, Thurston, which we all know Thurston is high quality court. So let's catch this. This gets juicy. This poor Judge Guy, she's been dealing with it all day. Oh, man. All right, let's go.
And so when he said that, he said he wasn't going to give me any more money from that day forward. And I was like, that's fine. And I said, well, you can leave now. So he got upset, tried to grab me. He took my keys and my cell phone because I was going to leave once he did that. He told me to go sit down and cool off. I was trying to call my sister to come pick me up because I was going to leave the house. He was saying, no, you're not going to leave. You're going to sit down and cool off. Well, eventually I sat down and tried to cool off, and I went out the door, made a way for the front door. My daughter started screaming, and he was like, get your ass in here now. And because my daughter was standing at the door.
Mikey, what's up, baby? How's California? California.
I came in the house and I sat down. And he said he grabbed a broken pistol off of the top of the refrigerator and said, if I called 911, I would have to call the ambulance as well because he was going to whoop me with the pistol. I sat back down on the couch. I didn't say a word to him. Before he proceeded to go to bed that night, he put my keys on the counter, told me not to leave during that night. I didn't. I waited until he went to work. at 2:30 in the morning. I called the police at about 5:30. I gave them the account of the event. I told them that I was leaving to go to Florida to my family. And I packed up my car and I left. Since then, I have not withheld communication with our daughter with him. Not unless he goes to arguing. I don't want that. I don't want her to be a part of that. So sometimes I cut communications when he argues in front of her with me on the phone or wants to speak to her. I bought her a phone. I said, you don't have to speak to me anymore. You can call her directly. He had her cell phone number and everything was fine. He asked if I could come back to Georgia. I wasn't working. Still at the time, my family allowed me to stay with them. No financial obligations down there until I was able to secure a job. So on February 28th, my daughter had a Black History event. I sent the video to him because he asked if I could send it to her. And I did. We were going to get food after the Black History event. My daughter told him that, you know, she was eating hot dogs and French fries. And he was like, well, where's your mom? I had a guest in the car and he was like, where are you ordering food from? I was like, I don't have to tell you where I'm ordering food from. Just know that she's eating. He called me a fat motherfucker and hung up the phone. And so I texted him. I said, do not call my phone anymore. From now on, you contact her directly. So that Thursday, he asked if I could have her call at 5 o'clock. Not a problem. She was at aftercare. I was assisting my cousin at her aftercare program, which she allowed my daughter to attend free of charge. I actually sent in the phone recording as evidence as well from that conversation. For 7 minutes and 21 seconds. He proceeded to speak to my daughter about how I am the reason why I'm bringing a wedge between their relationship. I left because I didn't want to be a wife anymore. I'm doing what I wanted to do, which is nothing. I didn't want to cook. I didn't want to clean. So I sent him an email and said, from this day forward, you will not speak with her until we go to court. I filed the order because I knew I had to come back to Georgia. I only have 2 places to come, and I didn't want any issues. So therefore, I filed a protective order against him, and I included Camille. And that's why we're here today.
All right, and do you believe that there was, let me ask it this way, why do you believe that this protective order needs to remain in effect for 12 months?
Because I don't need him coming to my house, because I don't have a problem with him communicating with his daughter. I don't have a problem communicate or getting her. Just don't bother me. Leave me alone. And every time he would speak to her, let me speak to your mom. We have nothing to talk about. Nothing, because it always turned into some type of argument or debate. So.
Okay. And looking through your petition, hold on one second. Is there anyone that you would trust to transfer your child back and forth between visitations?
I don't want to put them in the middle.
Okay. All right, is there anything else that you wish to testify to today?
Yes, I would like to be able to get some things out of my old residence, such as some pots, my air fryer, some of my daughter's toys, all my clothes and shoes and hair products, one of our deep freezers, the 2 small TVs, my work chair, 1 dog cage, my photography equipment and lights, my desktop computer, my wigs and my wig stand, my glasses and my firearm.
Okay. All right,
That
anything further?
escalated.
That's it, and I'm asking for child support.
You're asking for child support. Okay, and
And my gat.
have you prepared a worksheet?
Yes.
And where did you send the worksheet to?
I had it in my divorce case, but I also Ms. Johnson had me to email it to, give me 1 second, in Kara Broom.
All right. Ms. Alsop, do you have access to that worksheet? Anyone have access to that worksheet?
To the child support worksheet?
Yes, ma'am.
No, she didn't put that. Let me see.
She sent it to Miss Brame, I think.
Oh, she did. Her personal email, then I wouldn't have access to that.
Okay. Let me ask you, ma'am, if you'll go ahead and can I have you forward that to Miss Goodman?
I sure can.
Miss Goodman, if you want to give her your contact information in the chat would be fine. We're going to have her contact information put in the chat for you.
Okay. And Your Honor.
This court.
Okay.
Yeah, that has to be handled through the divorce court. Okay.
Okay, that's
Okay. Miss Goodman, were you able to send her your email in the chat? Miss George?
No, I did not receive anything through the chat.
But the argument was prior to that, and I sent in a video of that too. My wife, we was in a total loss car accident, and we had been having financial struggle. Okay. I sent my wife the week before we had sold a dog. My wife had a woman retreat plan. I gave my wife $900 to put towards the car when she get back from the women's retreat. When she got back from the women's retreat, and it started way before the 29th, I asked her, I said, babe, what did you do with the finances that I sent you to put down on the car? Because like she said, we are dog breeders. We are full-time dog breeders. I have 6 dogs right now. When she left, I had like 13. I did sell the litter because we was behind in rent, $10,000, man. We had an argument before us guns. My wife and I, like I told the advocate, she threatened me because as you can follow back, every time I cut money short, she get violent. My wife feel like I owe her a certain amount of money every week. Don't remind you, she haven't been on unemployment that long. She was just going through the process. Unemployment wasn't even really kicking out. All that's in text. The argument we got into was about me telling her I wasn't giving her no more money. She said, this is what my wife said, before you handle me like that, I'll blow your brains out. I told her, and when you do, and we did, she did have the gun. I say, matter of fact, I'm gonna call the police and let them know so they can get fingerprints off the gun. My wife did not call the police because I told her I would have the police to come in and fingerprint the pistol. Okay, she didn't call the police. She waited till I went to sleep. Now, we went to sleep fine and dandy. A person that was in fear, we went to sleep. I woke up and went to work. She called me about 12:30, 11 o'clock, because we did discuss separation. Remind you, we had them been through an altercation back in 2021. And with us going through the car accident and getting this money settlement, which we just got a couple of days ago, we was gonna do a separation. But my wife told me, and I got it documented to the T, she said, baby, in 90 days, I'm gonna have it the way you can't stand me. My wife started attacking my accounts. She started attacking everything that would make a rebuttal. Like I got my Wells Fargo, the business account that she admitted to that we own Blessed Bullets. She took the money out of there, shut that down. We got a Navy Federal account. She took the money out of there, shut that down. Okay. I start receiving emails. She started changing the account mail to come to Florida. So she did that. I think I sent that in. Then she went and had the rentals where we rent from, which we pay $285 a month. She went and had them to contact me and take her name off the lease. I was like, wow. Me as a husband, being together 8 years, I'm like, Carletta, what are you doing? Why are you doing all that? Why is you making a big deal? It's about Camille. You left me. At that time, the lady did volunteer to buy the puppies. The lady bought the puppies for 10 grand. Remind you, we was already in the hole. Okay. She bought the puppies for 10 grand. I took the majority of the money and paid up on rent where I wouldn't be homeless. And if we did go through a custody battle sooner than later, I would have a place for my daughter to come. Like I showed the lady, I have a check right here. We had to pay let's see, hold on. I'm still in it. We had to.
Is this the ghost of her husband, or is this her husband? He's a spirit. He started out light, now he's just a ghost. I feel like I'm watching Patrick Swayze.
To pay 2 checks. I had to pay 2 checks. One was $3,596, and the other was like $3,590 something dollars as well. I emailed you the renter's cost, but for us having a confrontation over the phone, we had confrontation regarding bills. We never did have no violence, like I'm gonna hurt you, besides what she said to me. And I told her, I said, go ahead and call the police, because they're gonna have your fingerprints on that gun. And they're gonna have, she didn't want to do that. She wanted to make it like I was the victim. I mean, I was the bad guy, which we've had altercation before when she bit me back in 2001, and I pushed her off of me and I scarred her on her lip because she was biting me. And I didn't mention that because we both would have went to jail. My wife do not like for you to handle her with finances. If you look at the emails I sent you, all we talked about was money, money, money. She did not stop me from talking to my child until I blocked her on Facebook, which I sent that email, and I cut the money off because she promised me several times that she was going, like you asked, to bring my daughter to see me. That's why I was sending money, because I told her, even in text, I think you got that one too. I say, Carletta, I pay for your flight and Camille's flight. Just, you'll have to stay like you're doing now with either.
Okay, so like I said, but I'm sure Kitch has the rest. Like I said, I was doing a million other things on top of my job, so I promise I will either find it for you and post it, or we will get it from Kitch or looking at legal stuff. So let's check it out. So now we're gonna go to see it. I couldn't even get it again. All right, so this one I got all of it, all of this one, and we're gonna go through this one. And this one is I would think this was the best one of the day. It got very crazy, very quick, and then we have
this conduct is like.
This one is brace yourself, people. Just brace yourself. Get your children out of the room.
Likely to occur in the future to petitioner and his immediate family without the court's involvement. Direct testimony and evidence will show that respondent has committed the offense of stalking, including contacting petitioner without his consent in a harassing and intimidating way. This conduct is willfully directed at petitioner, causing him emotional distress by placing him in reasonable fear of not only his safety, but also the safety of his immediate family members. We will demonstrate that this conduct is a part of a concerted pattern of harassing and intimidating unwanted behavior pursuant to OCGA 16-5-90. In consideration thereof, we are asking that Your Honor enter of any type with petitioner or his immediate family.
Yes, I do.
All right, go ahead, Mr. Rao.
Can you please state your name for the record?
Yes, it's Stephen, S-T-E-P-H-E-N, Damadeo, D-A-M-A-D-E-O. I frequently go by Steve, which is why you see it listed here as such as well. But Stephen is my legal name.
Stephen, can you explain how you know the respondent in today's matter?
Certainly, as you have previously mentioned in your opening statement, he has been the on-again, off-again lover, companion, partner, etc. of my wife, Courtney Damadeo.
How often do you interact with the respondent?
Rarely and only when absolutely necessary, because he happens to be accompanying her for some reason. It is my intention to do so as little as possible, as there's no specific legal connection involving parenting, custody, or anything else. So I would prefer it to be not at all.
How often has he contacted you?
Over the course of the last year or so, I would say of a fair number, though it has come in waves. He contacted me 23 times over the phone. On August 13th, he left at least four voicemails on that. He had showed up at my house when Courtney was actually fearful for her life from him. And he also came to my house and decided to attempt to stay in it while I was away on vacation that resulted in some of the events of March 5th and 6th that we'll discuss later.
Mr. Yamada, we'll get into a lot of those more recent actions. Do you maintain a call log of your calls?
Yes, sir, I do.
Would you recognize that call log if you were shown today?
Yes, I would.
Your Honor, I would ask the staff assistant to pull up Petitioner's Exhibit 1.
All right, Ms. Bream, if you'll bring up Exhibit 1.
Okay. And Stephen, do you recognize what's in front of you?
Yes, I do. It looks like a series of the missed calls from, I believe it was August 13th, 2022 from Mr. Nimmer.
And Miss Broom, can you show the petitioner and the court pages 2 and 3 as well? Mr. Damadeo, is this an accurate depiction of your call logs?
Yes, sir, it is.
Has this been changed in any way, shape, or form since the last time that you saw it?
No, it has not.
Okay, Your
Objection.
Honor.
Best evidence rule. This doesn't show my phone number or the timestamps of the calls.
Right.
Moreover, I would object to the legitimacy of these screenshots. Is there a call log from the provider?
All right, just one moment. Mr. Rao, if you'll go ahead and ask your client how this information has been entered as far as his name, Mr. Nimmer's name.
Sure. Mr. Damadeo, are you in control of your call log?
Yes, I am.
Did you alter or change Mr. Nimmer's name into another contact?
No, I did not.
Is this the best recording of your call logs with Mr. Nimmer?
Yes, it is.
Ms. Bream, if I could see the second page, please. And the third page. All right, go ahead, Mr. Rao.
Your Honor, at this time, I believe the correct foundational evidence has been entered to reflect Mr. Damadeo's call log with Mr. Nimmer. And I would ask this evidence I'd ask this be entered as Petitioner's Exhibit 1.
All right, I have heard Mr. Nimmer's objection. And as to the foundation, I am going to overrule his objection. I believe sufficient foundation has been laid as to the testimony that is being given by Mr. Damadeo. At the appropriate time, I can certainly hear from Mr. Nimmer as to any dispute he has to this information that is being presented to the court as Exhibit 1. So with that, Mr. Rao, you can proceed.
Absolutely, Your Honor. Mr. Damadeo, how many times did Mr. Nimmer call you on August 13th of 2022?
23.
Thank you. Ms. Broom, you can remove Exhibit 1 from your screen. Mr. Damadeo, has Mr. Nimmer left you voicemails?
Yes, sir, he has.
And what would you say is the nature of those voicemails?
Typically, when I get them, they're just general harassment type things. There's no
Exhibit 2. Can you play Petitioner's Exhibit 2 for the court, Ms. Broom?
Steve, you need to pick up your fucking phone, okay? Your bitch wife is harassing the shit out of me, and I'm gonna fucking sue you because you are still married to her, aren't you? I'm gonna sue your ass, okay, for damages because she's defaming me and she's slandering me, Steve. This is your problem now. You're letting her use your internet, sit in your house, use your vehicle to harass and defame and blackmail me. That is not okay, Steve. Nut the fuck up. Take control of your life, you bitch. You fucking bitch. You little tiny little itty bitty bitch.
Ms. Broom, if you could, there's a little bit left in the recording.
Cuckold. Pick up your phone, you miserable sack of shit, cuckold.
Thank you, Ms. Broom. Mr. Damadeo, whose voice is on this recording?
That is Mr. Nimmer's voice in that recording.
Was this voicemail left on your phone?
Yes, it was.
Your Honor, I enter into evidence what has been previously marked as Petitioner's Exhibit 2 as Petitioner's Exhibit 2.
Mr. Nimmer, do you have any objection to the voicemail that has been submitted for evidence?
I would object and call best evidence on that as well. And the timestamps don't seem to match the previously presented call logs.
All right, I'm going to overrule the objection. The voicemail will be admitted.
All right.
Mr. Damadeo, can you provide the court some context as to why that message was left for you?
I do not have any context as to why that message was left for me. From what I recall, there was no specific incident or pattern of behavior or direct interaction with Mr. Nimmer. Those were simply just all calls that were made and voicemails that were left without any provocation on my part.
Were you afraid when you received this voicemail?
I was definitely a bit concerned about the tone of the message because it clearly was showing anger. It was showing some instability, and that is not something that I want to have around. So I was genuinely concerned about what may or may not come out of that and or what was behind the messages.
Were you concerned that Mr. Nimmer at that time was going to seek you out in a personal context? And
He has a man bun and an oriental rug on his wall. Can we say El Douche?
person?
Not at that time based upon those. Any of the in-person things would appear later on in sequence.
Has the respondent ever threatened to harm you physically?
Yes, sir, he has.
When did that occur?
On or about the 5th of March, I had returned home from my vacation, and Mr. Nimmer and I had a verbal altercation in which he made a direct death threat.
Is that what led you to file this current TPO?
That is, along with an additional incident that followed on the 6th, in which Mr. Nimmer showed and would eventually draw a gun in my home.
Did you file a police report related to the incident that you mentioned happening between March 5th and March 6th?
Yes, sir, I did. I filed a police report with the Snellville Police Department on March 6th.
Are you aware of any other police reports that have been filed against the respondent?
Yes, I am.
Who would have filed that one?
Courtney filed a police report against Mr. Nimmer in response to some harassing calls and unwanted contact that she had received on or about, I believe it was February 22nd.
Okay. Would you recognize those police reports if shown today?
Yes, sir, I would.
Ms. Broom, if you could pull up petitioner's exhibit 3 for the court. Okay. And Ms. Broom, if you could scroll down so that the witness can see the first report and then the second incident report. Okay. And Mr. Domadeo, do you recognize?
6th, it appears that that one was filed by Mr. Mr. Domadeo. So I will enter that one. The first one, as it relates to, I believe Courtney Domadeo, she filed that one. At this time, I will not enter that one into evidence because there's been no evidence submitted for that one. All right.
Understood, Your Honor. We'll discuss Mr. Domadeo's incident report.
Okay.
Guys, I sped things up just because I didn't want to miss this for you. So if it's sped up to 1.5, it's because I really didn't want to miss it because I didn't know when they were going to cut it off because I was live at this point. I was just about live at this point, so that's why I didn't jump in and all that.
Mr. Domadeo, let's walk through the events that occurred that led you to file that. Why did you file that police report?
So on March 5th, I had, like I said earlier, I had gotten back from being on vacation for a week and a half. During that time, I had left Courtney in my home with our 4-year-old daughter. That is Sydney. She was there. At some point while I was away, Mr. Nimmer apparently had re-entered my home without my consent, obviously. And when I had gotten back, early in the morning. I had found that the two of them were sleeping upstairs in the bedroom that she had been using. She came down, I want to say approximately 12:30, 1 o'clock or so, simply came over, looked at me, said something to the effect of, he wants to go out. In this case, he was referring to Mr. Nimmer. And so they had gone to leave. Mr. Nimmer came back up and he and I had gotten into a discussion, which then turned into a brief verbal altercation in which I had verbally informed him in the presence of my mother, who is a witness that I know you will call shortly, that he was not a resident of the town. He did not need to be here, and that I had wanted him to leave, and I felt that his presence in this made myself and my family feel unsafe. In the process of doing that, he then responded with several expletives. He told me F you and probably north of 7 or 8 times. At that point, he also stepped up and closed down any personal space that existed between us. The place where I was standing, there's actually a baby gate there because
And anyone who was watching this, they can concur with me. They did that. It just cut. We all panicked. We were like, is this going to come back? They cut it. It never came back. So this was from start to finish. I promise you. People in the chat, back me up. I am not fibbing here. This is what happened. And then it cut. Are you kidding me? All right. This TPO is a 2-parter. I got it all. It is juicy, not as cuckoldy, but it is juicy. It's got everything. The son testifies. It is great. Here we go. This is definitely tpOMG. Here we go.
I received a packet of information for the contempt hearing, and there was the protective order I missed in the back of the paperwork.
Okay, and was there a notice of hearing attached to that paperwork?
No.
Okay, and so do you recall there being a notice of hearing for any type of hearing, not on the 29th or on the 26th?
No.
Okay, and Your Honor, actually, if you could, so.
You need to bring up something on the screen?
Yes, it's Exhibit 1, Madam Clerk, and Ms. Hurst, you recall sending me a copy of the documents you received on that day, is that right?
Yes.
Okay.
Oh,
Madam
I
Clerk.
have that, Judge. Do I have that?
I'm sorry, sir?
Do I have that? Is that something that can be put up on the screen? I don't see it.
Yeah, I'm trying to get that put up for you.
Okay, thanks.
Okay, is that Exhibit 1? These might be respondents' exhibits.
Yeah, that's
Okay,
Mr. Hurst Black Eye from her.
So that would be the petitioner in that case. So we need the respondent's exhibit 1, and that's filed on January 12th, Ms. Broom.
Okay, I'm sorry.
That's okay.
And I believe I submitted them all together. I wasn't sure how the hearing was going to go today, so it would have been petitioner's exhibit 1 under case number 23PO, and I'm blanking on the date or the actual hearing number.
2478. Is that?
There we go. Yes, thank you. All right. Yes. Now, Ms. Hurst, is this are these pages from the service packet you received from the respondent?
Yes.
Okay, and these are just photos or scans of those documents that you sent over to me?
Yes.
Okay, and have you manipulated or removed any documents from this packet?
No.
Okay, and Your Honor, I'd like to admit Exhibit 1 into evidence.
Mr. Roberts?
Okay.
All right, no admitted.
And Madam Clerk, if you could please scroll down to page 5, I believe it would be. Okay, and so Ms. Hurst, after discussing, the service issues, we discovered this document here. Is that right?
Yes.
Okay, and this is a service, a notice of hearing for courtroom 1200D. Is that right?
Yes.
Okay, and the highlighted sections on this document were those highlights made by you?
Yes.
Okay, and so
That's
those
it.
highlights you made? Okay,
Yes.
and so this was the only notice of hearing that you received at the time you were served by the respondent's private servicer?
Yes.
Okay, and that reads for December 6th, 2022 at 9 a.m., correct?
Yes.
Okay, and you didn't receive a notice of hearing for a hearing to take place on December 29th of 2022, is that right?
Correct.
All right, and Madam Clerk, you can please remove this from the screen. Okay, and Ms. Hurst, when did you file your motion for reconsideration?
It was. I'm sorry.
Okay.
I'm sorry.
And if I had it right in front of me, I would assist you.
I'm sorry. It was on. It was January 5th. I'm sorry.
Thank you, Super
Okay.
Rod.
And this is following the hearing on the 29th. So did you receive any notification from the court of a hearing date, a Zoom meeting link?
No.
And why do you know that you didn't receive a notice of hearing for the December 29th hearing?
As far as going through all of my paperwork and all of that, it was never sent to me. I never got the papers that send a Zoom link, the date, the time, or anything like that.
And do you have all of your court documents?
Yes.
Okay, because you've gone through this process before and are aware of the importance of those forms?
Yes.
Okay, thank you, Ms. Hurst. I have no further questions.
Can I ask her a few questions, Ron?
Of course, Mr. Roberts.
Ms. Hurst, I'm looking at the affidavit of service from Mr. Davidson, and paragraph 2, I don't know if you have it in front of you, but it says, I served Ms. Hurst with a notice of hearing, 1200D for December 29, 2022 at 9 a.m., family ex parte protective order notice of hearing. Are you saying that this gentleman filed a false affidavit, that he did not serve you with that?
No, I'm saying I didn't get the hearing that was rescheduled information for the next hearing.
Okay. So are you telling the court that's why you didn't show up on December 29th?
No, I'm saying I didn't show up there because I missed it, but I didn't get the rescheduled hearing because I would have shown up on the next time.
What affected on him?
I'm sorry, I couldn't hear you.
Judge Edgerton, we showed up at every one of those, and he wouldn't have the hearing because they were never served on Mr. Hurst.
I can tell you that I was not given the correct address, and even Judge Edgerton was the one who was putting the address on the protective orders. That was his address that he had found.
You don't remember me giving your previous attorney the exact address Mr. Hurst was living
That was
at?
to Judge Edgerton. You did, and that was given without me knowing. It was emailed to me by the other attorney.
Okay.
That was when we got the right address, and it was a paid private server that served him because of that.
So do you now know the reasons Mr. Hurst was asking for a TPO against you because of all these abusive and excessive emails you have been sending him, and text to over 300 texts that you have sent to his work? Do you now know?
Have you read them?
Let me interrupt you, Mr. Roberts. Let's keep it just to this reconsideration at this point.
Okay, sure.
I'm actually, if I could, I'm actually curious, Mr. Branch, if you can explore that there were continuances during December. And at each of these continuances, it looks like Judge Edgerton allowed it to be reset once to the 13th or the 15th, and then again to the 29th. Can you walk me through that so that I have a better understanding? And then I'm going to let Mr. Roberts ask any other questions he might have.
Yes, Your Honor, and that's something that me and my client have gone through at length, trying to understand where we stand in this case. So it looks from the court records, it looks like this case was initially filed and reset because no service had been perfected. And then it continued until she was served on the 21st, where it was perfected because there was an affidavit submitted and documents were handed to my client. However, it did not contain the right Zoom address. Every court hearing that resets, there's a new Zoom link, a new password, new information. And without that information, my client had no way of attending these hearings.
Okay. So it's your test, or I guess it's what your statement is today, is that your client knew that it was on the 29th, but had not received the Zoom entry.
Correct.
Suspicious reason for claiming that she didn't know about a hearing. She certainly knows the process. She's filed 6 now TPOs against Mr. Hurst. So.
All right. Do you have any other questions for her, Mr. Roberts?
No.
All right. And Mr. Branch, do you have any other questions for your client? I guess I would want you to explore a little bit about what you just testified or just stated.
Yeah, and so Ms. Hurst, could you walk us through what occurred when did you first find out that a TPO had been filed against you by the respondent?
Filed or granted?
Filed.
Okay.
It was, I found out on January 5th. When I was served in the morning with the contempt paperwork, and I missed it. So when I started talking to the women's advocates, they're the ones that told me that it was served. I didn't know I had received it. I didn't know to look out for another Zoom because I didn't know that I had missed that.
Okay, and you were served at several points in December, is that right? So those were for different cases?
Yes, I was served several different things.
And on any of those, did all of those service packets provide a notice of hearing?
Yes, every single one.
To the particular court hearing that you were supposed to attend?
Yes, every single one except, yeah.
Okay, and are there any other reasons that you were confused about the hearing date?
I think I was overwhelmed that I didn't see it, but no.
Okay, and thank you. I have no further questions.
All right.
Couple judgments.
Oh, okay. Go ahead, sir.
Ms. Hurst, you said this when you first found out about the contempt, but the contempt was not the TPO. The contempt was Judge Adams from a Superior Court hearing. So those were issued against you by Judge Adams, not the TPO court.
No, it was all from Ms. Hitt. All of the paperwork came together in one packet.
From who?
Ms. Hitt.
Who's Ms. Hicks?
Mr. Hurst, other attorney.
Oh, Eleanor Hicks.
Yeah.
Or his divorce attorney.
Yeah. It all came with it.
Okay. I don't have anything else, Judge.
All right. And the reason I set this down for the hearing on the reconsideration, which normally I wouldn't even do, but I was confused by some of the filings and and I'm glad we set it down because I needed to hear all of this today. But having heard and considered what's been presented, I am not going to grant the reconsideration. I'm going to deny the reconsideration. The existing protective order between David Hurst and Cynthia Hurst will remain in effect as it has been previously ordered. Service was made. It's very clear on the paperwork how to contact the office of the magistrate court as well as the clerk's office if there's any confusion as to which Zoom link to join and enter into. We have it happen often. And I understand you may have been operating off of the December 6th Zoom link, but in this case, there was no reason why you weren't able to at some point join during the December 29th hearing. So I am going to keep that order in place. So given that, we are in the posture today to hear solely on case 23PO2478, which is Ms. Hurst's request for a 12-month protective order against David Hurst. So I'm going to turn it back over to Mr. Branch for you to go ahead and call your witness again or witnesses to present your case as to the 12-month protective order request.
All right, thank you, Your Honor.
Judge, can I ask a quick question before we start that? I appreciate the court's indulgence on this. This TPO that Ms. Hurst is seeking today, she's asking that he be kept away from her, that he not have any contact with her. He is already under an order from his bond to stay away from her, which he has scrupulously done, except for the meetings to try to contact one another to exchange the child. That's when Judge Adams got involved through his divorce attorney, Ms. Hitt. So that's the only contact they've had. Nothing has changed since he's been out on bond, Your Honor.
And I appreciate that, sir, but I do need to hear the testimony from the parties as it relates to that. And it may seem unnecessary, but I do want Ms. Hurst to be able to testify as to anything that she may have experienced that we may not be aware of.
Okay, that's fine. Thank you. I just wanted to ask that question.
Mr. Branch, you may proceed, sir.
All right. So, Ms. Hurst, as opposing counsel said, you've filed several petitions for a protective order against respondent in this case. Is that right?
Yes.
And was the first petition you filed in 2022?
For this year, yes. Yes, but I dismissed it.
Okay, so before you got through the ex parte phase and then you dismissed prior to moving forward. And so tell me about some of the things that happened leading up to his arrest on September 28th.
In April of 2022, Mr. Hurst suffers from severe bipolar 1, and he does have cycles, and he has been admitted to Peachford Mental Hospital and rehab 5 times. And in April, he started to cycle again, and I knew it was coming. So it starts out with self-medicating, and then it becomes violent. And I did everything I could from April to September to stop it. I contacted his therapist, his psychiatrist, his family. Then it just got to the point where in August, I had to leave because it got violent. I had to go out of town. I had a welfare check done on him.
Okay, so let me stop you real quick. And so in April of 2021, is that right?
22.
Okay, so in April of 2022, you two are living together, is that correct?
Yes.
Okay, and so between April and August, when you said you left, what were some of the incidents that led you to believe he had moved into this part of the cycle?
Physically, he was unable to function. His temper becomes short and just erratic. He started meeting with his older daughter to obtain additional drugs. He left a bag of crushed pills out that he had been snorting in the bathroom. He hides alcohol. He had gotten lost in a parking deck. He was going to go stay, but as far as violence and stuff, it just snaps. I could be talking to him, and I think in one of the videos I showed, we're just talking. I was filming him cooking to send to our kids, and he just snapped and whacked me. And it's out of nowhere because it's not normally him. But I know when it's starting to cycle because he has hallucinations. He can't get out of bed. His antipsychotics were doubled, and when you mix that with alcohol, he becomes violent and short-tempered, even towards our son.
So, Ms. Hurst, what are some specific things that he's done to you during that time frame?
So this one he did it happened in front of our son. This was when I knew it was happening. We were in a hotel room, and I come back.
I'm sorry, can we clarify what time we're talking about? What
April
date?
22nd.
Wait,
April.
wait 1 second, Mr. Branch, if you can get your client to clarify.
Yeah, and so we are talking about April 2022, is that right?
Yes.
Okay, and so what happened in April of 2022?
So we were staying in a hotel in New Orleans, and my son was scared to sleep in the bed next to his dad because his dad was incoherent. He was completely out of touch. And he was sitting in the corner, and my husband was yelling at him to get in the bed, and it was intimidating him. Well, I switched places with him because my son was scared of him. So we were laying in the bed, and he rolled over, and he put his elbow right to my face, and then kicked me in the crotch as hard as he could. I bled for 2 days after that, and he did it in front of us. So then it just went on from there.
Okay, is there anything else that happened during that spring of 2022?
Yes. Like I said, he wanted to drive under the influence. And it's a long history of blackouts. And more than once, I tried to stop him that ended up with him hitting me once, twisting my arm behind my back another time. He told my son I was just being a drama queen, and he threatened to kill me in front of him.
And when did that happen? When did he make that threat?
That was June, July, and then it happened again in August. Twice he threatened to.
And so what type of threats has he made against you, all specifically?
Well, the first one was I had gotten COVID, and I had just gotten out of the ER.
And when was it?
Yeah, I mean, the ICU. And I don't remember why he was angry, but he told my son that because he has always, his thing is he likes to cancel things, take the money, and lock me out of the house. But he told my son that he was going to cancel my health insurance, and he'd make sure this time COVID killed me. Told my son that. Then
when did he make that threat to your son?
That was right at the end of May, June.
Okay, and you were present at that time?
Yes.
Okay, and so when you were, did anything else happen regarding? Was he involved in you going to the ICU at all?
Yeah, I went into septic shock, and he wouldn't let me call. He wouldn't give me the phone to call 911. and I passed out. And the next thing I know, I was in the car going to the hospital, but he would not give me the phone to call 911. And I just remember it going black. And I went to septic shock. And my son witnessed that too.
And so did anything else occur between, sounds like May till September when he was arrested?
Yeah, so further down in the summer, August 2nd, like that time, 2nd to 4th, August 2nd to 4th, we were, he was drunk. He was really, I don't know if he was drunk or intoxicated, both, mixing his meds with it, but he had been in his bed, his office, and I went in there to talk to him, and then all of a sudden, out of nowhere, he just called up and kicked me out of his laying in bed and kicked me across the room.
Okay.
That was August, because then we left because I couldn't take it. I had to leave out of town, and he wouldn't go stay with his family. He couldn't drive to go to the hotel or stay at a hotel. He couldn't function. But it was like out of nowhere. It just happened out of nowhere.
Okay. And so let's move forward to what happened in September of 2022. So
Okay.
what are some of the things that occurred by the respondent did that led you to file your TPO petition?
Okay, so it had been, his intoxication had been increasing to where it was nonstop for at least a week. So we're talking September 23rd, drinking, doing whatever on top of it. He also was hallucinating, and when he hallucinates, he tends to self-medicate more. And he could not drive. He was trying to go places with our son. I had told him that he came into my room on the 27th at 4:30 a.m., the other bedroom. He asked for the keys for my car to take my car to go get more alcohol at 4:30, and I wouldn't give them to him. Like, he took the keys, and I got onto him. I'm like, you can't drive, and he held off and threw the keys at me. So on the 27th that day, he was trying to get into my car, which is bizarre in itself. And I wouldn't let him go. I told him I was going to call and have him because he's going to get in a wreck. Somebody's going to get hurt. He took the keys to my car and just scratched my car up. And then he turned around and charged me. And my son was in his bedroom, but he heard me yell. My son tried to step in the middle to stop it. And he went past my son. He grabbed my arm, twisted it behind my back, and he took the keys like he was going to cut my throat. I mean, it's dull. It's not doing anything. It's just making it red and bruised, but it's not cutting my neck. But that's something that he has threatened before, to slice my throat, what he says, and it's that graphic. But he looked at my son and said, "She's just being a drama queen." And
okay,
that's when I was like, my son wanted to call the police right then. And I said, let's give him another day and see if he's going to be sober tomorrow. I didn't say sober, but I was like, if he's better tomorrow. I didn't want to call. And he got back up and started drinking again. And he was in the car, and I called the police, and they came. He had told him he was going to get breakfast. He did not. He went and got alcohol, and he left it in my car with the receipt. And the neighbors were parked in front of my neighbors so they wouldn't see what he had gotten. But they did arrest him because I had marks from the day before when he had his hand around my neck and somehow the key broke on my face too. The fob did. And I don't know.
Let me stop you right there in person. Madam Clerk, could you please present exhibits 2 through 6?
Okay, so I'll do the first one, which would be 2.
Could you say that again? Yes, okay, perfect. And is this you said you were grabbed during that altercation with the respondent, is that right?
Yes.
And is this a photo of that bruise?
Yes.
Something that occurred from that? And when did you take this photograph?
I think it was the 20, it happened on the 24th, so probably the 28th.
Okay, and Madam Clerk, if you could scroll down to the bottom, the next page. And is this a screenshot? This more accurate representation of when you took that?
Yeah.
Photograph?
Yeah, it was within that same period of time, 24, 20, yeah.
Okay, understood. And Madam Clerk, could you go to the next, or actually, so that photograph was taken on the 24th. So how did you receive that bruise?
We were just talking, and he was intoxicated, and he just got mad. And I mean, I honestly don't know what part it was, but he hit me, and it was in the bedroom. It was in his office. It was during that altercation in his office where he had kicked me and just lashed out at me for whatever. I don't know, because I was probably telling him he couldn't go anywhere or he needed to stop drinking.
Okay, and did you alter or manipulate that photo in any way?
No.
Okay, and Your Honor, I'd like to introduce Exhibit 2 into evidence.
Yeah, Your Honor, I'm not sure that's the proper foundation, but I have no objection.
All right,
I was
thank
just talking away, y'all couldn't even hear me. All right, all right, it'll be admitted without objection.
All right, thank you. And Madam Clerk, could you please show the next exhibit, Exhibit 3? Okay. And Ms. Hurst, when was this photograph taken?
That happened on the 27th. I think I took it on the 28th. That was from the whole thing with the neck that had happened when he scratched my car up and all of that.
Okay, so this is the incident on the 28th when he was arrested, is that right?
Yes, that happened on the 27th, but he was arrested on the 28th. Yes.
Okay, and when did you say you took this photograph?
I think it was the 28th. It was the 28th. I think it was the day that he got arrested.
Okay, and if we scroll down, Madam Clerk, I think we have timestamp. Is the 29th more accurate for when you
Yes, I'm sorry.
took this photograph? Okay.
Yes.
And have you manipulated this photograph in any way?
No.
Okay, and Your Honor, I'd like to tender Exhibit 3 into evidence.
Mr. Roberts, any objection?
Objection. Okay,
Admitted without objection.
thank you. And Madam Clerk, could you move on to Exhibit 4?
Peach.
I think it was the 24th as well, because it happened, I think, at the same time with the incident that he was in bed and I was in office.
I think the car's the least of your concerns, lady.
All right, and so you said the police were called.
They're still pending and he has additional charges, but I can tell you, my son has said that his dad is drinking and he knows that he was using drugs inappropriately and he doesn't want to have anything to do with that. As much as I'm concerned about being hit, I'm more concerned about him being in another accident with my son. And my son, he had blacked out at Ashford Park about 4 years ago on their property, and he was taken and admitted from Northside to Peachford, but they involved a social worker and Child Protective Services, and they did talk to my son about being aware and cautious of getting in the car with his father anytime he's been drinking. And he tends to hide his alcohol. He hides it from me, period, because he does, whatever. He said he's not going to drink. He hides it in the car. And my son has said he's drinking since this has been going on again within the last month.
You claim that he does drugs as well, and
yeah,
those are not prescription medications, as far as you know?
They're prescriptions, but they're obtained not from his prescription. And then they're also, he's been denied service for obtaining illegal prescriptions for narcotics from additional doctors and been dismissed from treatment because he was getting prescriptions from other clinics. And
have you ever discovered any of his narcotics in the home?
My son found a bag in his office bathroom of crushed, we think it's Adderall, and a spoon and a straw, and it was in his bathroom. He left it in there along with empty containers that he was hiding, but he left that bag out on top of his counter, and my son walked in and found it, and that's how I knew it was there, is because my son came and got me and told me.
Okay, and Madam Clerk, could you please show Exhibit 20?
Judge, give me 1 minute on 20. I don't see an attachment, so I have to go look for it.
Okay, thank you. And let me know if you can't find it, because I can pull it up.
Her? She sounds pretty convincing. I don't know. I saw somebody.
Your Honor, just for the record here, if this is something that her son supposedly found and told her about and showed her, we're going to object as hearsay unless she produces the son to testify. She's just going to testify to, my son gave me this and said so and so. That's totally hearsay, Your Honor, and I would object to it.
All right, Mr. Branch.
Yes, and the son is available to testify if necessary. We're trying to keep him out of this case as much as possible, though. So I did
find it. I found it. I'm ready.
All right. So, Mr. Branch, go ahead and finish before we bring it up.
Yeah. So then I can move on from this exhibit if it would need his authentication.
Based on what she has stated up until this point, I am going to sustain the objection.
Okay. Understood. Then I'll move on from this line of questioning and we can cycle back around.
Okay.
All right, thank you. And all right, so Ms. Hurst, you filed your TPO in October. So have you and the respondent been living in the same residence since October?
No.
Okay, and so in what way has the respondent still interfered with your life since him moving out?
He immediately cut off all access to all finances. And my son is in school. He canceled the lease. It was not expired. Refused to give me the information. He would not give me the information for our utilities, and he would cut those off and not even give me the information to pay them. He did not he's not paying the correct amount of child support, but that's not even what we're going to discuss. It's the fact that my son is in a homeschool program, and that was only because we thought we were moving. I gave him 30 days notice that I was going to move. Then he sent in the modification and told me I couldn't leave. So I was in nursing school. He took all the money that I had contributed through my scholarship and my stipend went with him. My parents have been paying for all the things that I needed. Now the few months of child support went to pay the premiums that, for example, he canceled the car insurance. It was a negative $800, $900 I had to pay to reinstate it. He overdrew one of my accounts to $800, $900 as well, almost $1,000. So then what I have done to balance those out. But it's interfered with getting a job because I don't know where I'm going to live, where I can register him for school because I don't know what county. So he's, it totally changed my life. And I knew if I didn't secure the house that it was going to happen just like this, because that's what led to our divorce. He had the locks changed when he was in rehab, and my son and I could not get back into the house, and we never got back in to get our own personal belongings. Not even again, my son was in school, and it caused my son to have to repeat a grade because he could not attend school. And that leads me to the fact that the time he's spent with his dad, he's only been to school twice for 2 days. So that's a concern.
So, Ms. Hurst, I want to focus on some of the accounts that were canceled during this period. So this is sometime between October 2022 and today, is that right?
Yes.
Okay, and so, Madam Clerk, could you please share Exhibit 19, please?
Judge, can I interject here?
Yes, sir.
Judge, this is totally irrelevant because they are under a divorce order and decree that determines their financial responsibilities one to the other. Mrs. Hurst is just using these TPOs to try to get financials. This is what this is all about. And Judge Adams signed the divorce decree. They're operating under the divorce decree. She's been held in contempt for not complying with it. And he has no obligation to pay anything other than child support. Judge Adams has said that twice, 3 times now. And to talk about finances and a TPO when he's already under a court order to stay away from her, which he is doing, this is totally showing exactly why we're here, because she's using the TPO process to try to gain financial assets and advantages from Mr. Hurst, who's the only one that's been gainfully employed in this family for 20 years.
All right. Mr. Branch, if you could explain to me how any of this is relevant.
Yes, and this is not an attempt to receive a certain amount of money from this TPO. This is to show a consistent pattern of harassment that has been done, that is being performed by the respondent. These parties have shared accounts that they should have equal access to use and withdraw money from. However, now because of the respondent's actions, she has now been cut off entirely. So while we're not asking for money, this is something that could be resolved in another case or another court. This is a pattern of what the respondent does to inflict, emotional, physical, and financial damage
Laura.
to my client.
Okay, well, let me ask you this. Is Mr. Hurst under, when was the divorce finalized?
Finalized in 2018.
2018. Okay, so is he under any court order to pay any sort of spousal supplement here beyond child support?
I do not believe so. I think it is strictly by the agreement of these two parties outside of the court.
Okay.
Child support is the only financial obligation he has.
Okay. And what is it that you're attempting, before we get into the specifics of it, what type of accounts are you attempting to show that she no longer has access to?
There are three, there's a shared bank account and then 2 credit card accounts that she has been removed. There has been changed passwords, overdrafted money, and another one has been put on restriction as well.
And are these his accounts or a joint account?
They are joint accounts.
The credit cards are joint accounts?
I believe that is correct.
I don't believe that is correct, John.
All right, well, I'm going to need to see it. I'm going to go ahead and overrule the objection at this time. I'm going to have some more questions about this, but let me see the joint account that we're talking about.
And so I think the evidence that we have may not be able to clarify everything.
She would be able to give testimony under oath as to what she is indicating here.
Okay, perfect then. And then, so Ms. Hurst, could you please explain to the court what this photograph is representing?
Yes, it's a Chase account that we both had access to. Both had monies that went into them. We both contributed financially to the home. Like I said, gainfully employed. I received a living stipend and a scholarship. That was my job, is to go to nursing school and to do our son's schooling and activities. That was my job. This was an account that I used to buy groceries out of for my son. And as far as me, it's not about me. It's about taking care of our son.
Okay, Mr. Branch, if you could ask your client who owns this account.
It was both of ours. I'm sorry.
And so who opened this account, Ms. Hurst?
I'm sure Mr. Hurst did.
Okay, and is your name listed anywhere on this account?
No, not anymore.
Not anymore. When did that change?
Yeah, it's not even open. I mean, I have my card, but it doesn't work.
So when did your name when was it removed from the account?
The week he got out of jail.
Okay, so that was in October of 2020.
Right, first week of October.
Okay, and then Madam Clerk, if you could scroll down to picture 2. And could you explain to the court what this photograph is representing?
That's a Wells Fargo account that we both had access to, my name and his. And it just, because he let the bills come in, but was not cut off the other money that was going to it, it just kept with overdrawing it. And now it's closed, of course. And that's one of the things I had to pay to get out of the hole.
Okay, understood. And then the last photograph is representing what?
That was an Iberia account that one I did have access to. I don't know about my name being on it because it was through his trust, but I do have a card and I did have access. And I don't know if he ever added my name to it or not, but I used it as it was my own. I used it as a deposit account for my money and used it to pay bills.
Okay, understood. And so as far as you're aware, the first 2 accounts your name was attributed to those accounts until October of 2022. Is that right?
Yes, first week of October.
Understood. And when were these screenshots taken?
Those were taken that same week because I couldn't get into them.
Okay, so a week early October 2022, is that right?
Yeah, I can tell you exactly, yeah.
Okay, and Your Honor, I hope that provides some clarity to why we're discussing it I understand though if you feel that this is outside the scope of the TPO.
Well, and why I wanted to hear the testimony is to get an understanding as to why it was coming in. I am going to let it come in at this point based on the testimony, and as to what weight I give it will have to be determined.
Understood. All right, thank you, Your Honor. And so, and then Ms. Hurst, since October of 2022, has the respondent done anything else that you feel has been harassing behavior?
Taking my mail from the mailbox and things off of my door, and canceling utilities, and not giving me the information so I can even pay them or expect to know if they're going to be cut off. For example, my son does hybrid education. I got to have power and I got to have internet, and they've both been cut off before, and just needing the information so I can prepare for it or I can state it so it doesn't cut off again. It's been withheld.
Okay, so since the October or September 2022 incident, have you had to call the police on the respondent at any other time?
Yes. My son did call because he did not want to get in the car with his dad, because it was the last time we'd seen him. It was just, he was completely unable to function. And my son told him he did not want to go. He did not wish to go. We had an ex parte order already signed, waiting for the hearing. And my son called 911, and they did a report because that's what they told him to do, to make sure you report and document it all.
Okay, and when was that report taken?
That was going to be in late October, mid-October. It wasn't too far after everything. It was, yeah, I can tell you.
Okay.
It was actually October 29th, I believe.
Okay, and then
right before Cal Point.
So in 2023, have you had to call the police on the respondent at any point?
Yeah, I had to do a report because the leasing company guy had somebody come at 7 a.m. to remove furniture. Well, the police had told him you can only remove furniture that is agreed upon. And what they did is they went out the back door and took everything and loaded it up. All of my bedroom furniture, all of our tables, all the stuff that is daily stuff that is just, I would have given to them had I known, so we could have split it, but they refused, and also took my wallet on accident. And I don't think they did it on purpose, but I had to report it so I could have the documentation of what was taken.
Okay,
So.
and Madam Clerk, if you could please share Exhibit 8 with the gallery. Okay, and is this the police report you're referring to?
Yes.
That was involved. Okay. And based on this report, it looks like the respondent is not listed on here. So why are you attributing this incident to the respondent?
Well, I didn't know he was not listed because I would assumed he would be. It doesn't have anybody's name on there.
So do you see the Arthur Hinson?
I don't see it down. It may not be scrolling. Oh, now he's the gentleman that removed the stuff that the police actually talked to. So they had his information, his name. But I'm surprised. I didn't realize that David's name was not, Mr. Hurst's name was not on there.
Okay, and so Mr. Hinson is Madam Clerk, if you could scroll down to page 2. So page 3, actually. Sorry.
It's just got his name, Mr. Hurst, her ex-husband, I see, and Arthur Hinson. They just blacked his name out.
Okay, and so who is Mr. Hinson in regards to this police report?
he I thought he was a mover or a moving company that he hired, but apparently hired through the management lease company that he is part of that company. And he came with movers in a U-Haul van and about 5 or 6 people to come in to the house and just take things at 7 a.m. with no notice. I had no notice. And like I said.
And so was the respondent supposed to contact the sheriffs or anyone else to collect his belongings from?
I thought so. That's why I contacted them.
And you didn't
I thought
receive any notification about this incident?
No notification.
And Your Honor, I'd like to tender Exhibit 8 into the evidence.
All right, any objection, Mr. Roberts?
No objection, although that Mr. Hurst had nothing to do with that, Your Honor. That was the leasing company.
All right, it'll be admitted without objection.
All right, thank you. And Ms. Hurst, is there any other incidents that you'd like to share for why you feel that you need a protective order against Mr. Hurst?
I do feel like that because I was unable to retain an attorney, that a lot of my concerns, in fact, I'm the one that called for help, have been overlooked. And because he was able to move forward with other types of petitions or filings, that the gist of it, the important part of this has been completely ignored. And that's the fact that the abuse has gotten so bad that it's including our son now. His actions as far as drinking and doing things that are not legal have gotten to the point where they're going to hurt someone, if not himself, because I have been scared I would find him passed away from his actions. It's gotten worse, and I think that that's been overlooked and said that I want money and all this. I don't want any money. I just want it to be done. I just want it to be done because I can't handle that anymore. I can't handle shielding my son from it, and I can't handle the fact that it's getting more violent and that it's scarier than it's been before. It's been more, there's not been any restraints on it lately, where before there would be restraints. But since April, it's been completely different than what I'm even used to dealing with the other stuff. Much more short-tempered, much more physical.
Okay, thank you, Ms. Hurst. I have no further questions.
All right, thank you. Mr. Roberts, do you have any questions for this witness?
Yes, ma'am. Ms. Hurst, all of these accounts that you gave that of actions that allegedly occurred between April in 2022 and September of 2022, when you had Mr. Hurst arrested, you continued living with him between April and September at his house that he leases, correct?
Yes.
Okay. And you came, and when you filed your first TPO against Mr. Hurst, after you had him arrested, which was on October 10th, you didn't list any of those items that you just recounted to the judge in your petition for a TPO. You only talked about the incident that allegedly occurred on September 27th, where he scratched your neck with a key and grabbed you and put a bruise on your neck, correct?
Up until that point, I only thought I was able to do what he was arrested for. On March 10th, the rest was reported, so it would be included. And there are videos of what happened. There are videos, and there's no objecting to what happened. It did happen. So on March 10th, I met with the sergeant and the officer to correct the report. And actually, we filed an additional report for those that I just mentioned because there is evidence of it. There's photographs, timestamp videos, and they were able to file a report.
When was the last time you were gainfully employed, Ms. Hurst?
Back to this, I promise. We're getting back to this, promise. But it's long-winded. We got 400 in the room. I got a couple funny clips. Let's take a little break, and then I'm going to go right back to this, all right? We'll go right back to it. Just give everybody a little quick stretch, get a break from this. Running mascara is always a good thing for court shows. Helpful hint. Here we go. Let's get a little funny. Oh, speaking of crying.
Letter write, if you would.
Well, it looks like we have two on the warrant.
What is
Creft, all right.
I try to do 5 a month. She went.
And
attendance record. If it turns out to be a problem, once medical staff over there have had a chance to look at it and council have had a chance to talk with them.
And you're on. And let me ask you, Mr. Weber Collier, let me ask you real quick here. First of all, where are you currently living?
I'm actually bouncing the couch to couch, but this is a permanent residence at 1326 Eleanor Avenue in Shelton, Washington.
Okay, so you're
That's
still in the Shelton area.
Yes, that's where I'm staying, and that's how I'm trying to get to court.
And I am curious what you have been doing these last 2 years.
Honestly, Your Honor, I had a cardiac arrest, 2 heart attacks, and a stroke outside the Woodlands, Texas mall. And I cannot move this whole right side of my shoulder because it's a frozen shoulder. And then I got blood clots all up and down my legs. So I've been unconscious in the hospital for about 6 months.
You left the state and went to the Woodlands, Texas?
Yes, because I had a family emergency out there. My mom passed away.
Okay. All right. Yeah, you're in a tough spot, Mr. Weber Collier, because the prosecutor.
My mom.
Well, the prosecutor's not wrong. You've walked away from all your obligations. Nobody's heard from you in 2 years.
I tried to contact my mom, tried to contact the court and tell them I was unconscious. My grandma even knows.
Yeah, well, I do note here that the court clerk noted yesterday that you came into the court at the front counter to turn yourself in, and I do appreciate that. I think that says something about your willingness to do something positive for yourself, not just avoid this.
I want to see my mom's ashes in the box.
Mr. Weber Collier, for now, I'm going to follow the prosecutor's suggestion. I'm going to continue to hold you until.
Can we please let me out, please, lawyer?
Thank you, Robert, with the 50 dono.
I just want to go home to my mom's ashes.
Miss Langley, I'm going to appoint you on Mr. Weber Collier's case, and we'll set him on for your calendar on Monday.
Hey.
Medical, we got one. So I'm staying in jail until Monday?
Until Monday. And if we have better information, another placement, I don't know, I'm not promising anything, but there's an opportunity to get you into another situation on Monday. Yes. So continue the no bail hold until Monday the 3rd.
Is there anything I can do to be on anklet or house arrest or anything to get out today, please? I have a new job and I need to get to it. I work at Jack in the Box.
No, we're unfortunately, no, we're not going to do that.
I work at Jack in the
What
Box.
can I do to get released and let you see my proof of me going to work and me actually stepping in that courthouse?
Yeah, I told you, I already know that.
Can I talk to the state? Is there any way I can talk to that gentleman?
Nope, you can't do that. You're gonna talk to Miss Langley and she's gonna help you out. And she's really good at this, so you're gonna be in good hands. You're gonna have to hang on till Monday though.
Thank you so much, Robert.
All right, we're all done for today, but we'll see you on Monday.
Yes, sir.
Okay, and then let's go over to the county jail and
Portia Mullins.
Crying? Who's crying? Oh no!
Ms. Mullins, you're charged with a Class B misdemeanor theft of service. The bail is $3,000. You understand the rights I gave you?
Yes, yes, sir.
You understand the rights that I gave you?
Yes, sir. Because I don't qualify for the PR bond because I just signed up for it yesterday.
Houston?
Yes, sir.
Um,
I promise I won't be in any trouble. I was just wondering if I was available for the PR bond.
So you go sit down, I'll take a look at this.
Okay.
Maria Escobar?
Yes.
Why doesn't she just pick the
Ms.
lock with her
Escobar, you're
nails?
charged with a Class B misdemeanor theft of property. This is a warrant that was signed on July 2nd of 2018. Bond is $1,000.
I always wondered, how do you wipe your butt with those things?
We've also got a bond forfeiture here
Oh, poop on
on
the
a DWI, $3,500 cash or surety, and bail jumping, $3,500 cash or surety.
Allison,
Do you understand the rights that I gave you?
Yes, I do. It's been a while since
This is a crying in
that
court
happened, and
Yes,
I did
it
have
is.
a lawyer, and I had just had a baby at that time. It was raining that day. He told me that he'll reschedule me, but somehow it went. I don't know what happened. I ended up with bond
You're gonna have to figure out a way to post a bond so you can get out of jail. So you got 3 bonds, 1,000 and 3,500. Those are cash or surety. So you need to talk to a bail bondsman.
so I don't qualify for personal bond.
No, ma'am. Do you want to request appointment of a lawyer?
Yes.
Okay. All right, thank you.
All right, Wolverine, come back.
Oh, did you ask her to come back?
Come here, Catwoman.
Can I say something to you?
Ms. Escobar, you've got two,
A bidet.
you got a traffic offense back in March of 2021. There's a warrant for your arrest for failing to stop at a designated point and driving without insurance. That was on March 25th of 2021. So we can take care of those today, or I can set those for trial for you. You have all the same rights with these. This is a Class C misdemeanor. They're punishable by a fine only. You have the same rights on these charges, these traffic offenses that you do on the other. You'd have to hire your own lawyer for these. You can't get a lawyer appointed for you. So, do you understand the 2 charges?
2 charges. So total, I have 2 that I have to bond out on.
Failure to stop at a designated point. You probably went through a stop sign or something too far.
But that would be take care of.
And no insurance. You want to take care of those today?
How would that be taken care of?
Well, if you plead not guilty, I can set you up for a trial. You have to come back to municipal court, and you can have a trial by jury or a trial by judge alone. Or you can plead no contest or guilty. If you do that, you'll give up your right to trial and go on your record, and we'll take care of these today.
Robert, my man.
Okay, I'll do that.
Cheers,
You want to do that?
Yeah.
She's still, look at her wailing in the back. You're gonna be somebody's biatch. Look at her in the back. Oh, she just had it. She's done.
All right, Ms. Escobar, I've entered to find you guilty on set of fine. I'm giving you jail credit, so your fines are paid.
Time served.
Okay, good luck to you now.
I'll let her know you need to use phone.
Come on back, crybaby.
Ms. Mullins? If you get a personal bond, how are you going to get back here and go to court and all that?
I have a car. I got a brand new Audi on my birthday this year. So I do have a way back.
You heard that. Audi. Remember our debate? Audi. So this is Texas. In Texas, they say Audi. It's Audi. Audi. I'm telling you, that Audi debate is very geographical.
I will make it.
You have a brand new Audi?
Yes, sir. The Audi A6.
Brand new Audi?
Well, it's an old one. But I got one. I got it on my birthday. So I will make it back.
She got a brand new old Audi for her birthday. Tink! Thank you, Tink!
Okay, I'm going to give you a personal bond.
Thank you.
You could always smile.
I do not regret it.
We're going to give you a court date. You need to show up for court.
No problem, sir.
If you don't show up for court, they're going to revoke that bond, put you back in jail, and raise the bond.
Yes, sir.
You understand?
Yes, sir.
Okay. And you need to stay out of trouble.
Yes, sir, of course.
All right.
Well, thank you,
All right.
sir.
All right, go back to your cell, please.
Get out.
Do you need to use the phone? All right, so lock the
The
door
jailer
behind you.
could care
I'm
less.
gonna have
Told you that was a goodie. That was a goodie. All right, let's get back to the TPO. Here we go, TPO. I do have a really good Judge Webster, too. Really good Judge Webster. All right, let's go.
And an eviction letter at the same time. It's just been, I've had.
Any contempt actions filed against you recently
No.
for this, for the child custody dispute?
No.
Okay, and have you violated the TPO that's currently in place against you with Mr. Hurst?
No, I've used the Wizard app, and we communicate through the Wizard app, which is listed on his TPO.
Okay. And you said you're not asking for any money regarding this. So what is the purpose of bringing in your financial accounts, your bank accounts with the respondent?
Just to show that this is what happens, and it's happened before. This is a control tactic. In fact, he knows that this is much more worse for me than anything else, is not being able to know if you're going to be able to take care of your son the next day. He told me he would do it, and he did it.
Okay, thank you, Ms. Hurst. I have no further questions.
I have no further questions, Judge.
All right, just one moment. I need a little bit of clarification, Ms. Hurst. You indicated that you have made the attempts to exchange your child. Can you explain to me what attempts were made to exchange your child as per Judge Adams' order?
Yes, we were going to exchange him at the police station.
What date was that?
Approximately. I would say the beginning of March.
Okay.
So I did go. Now, the domestic violence unit has been working with me. So they wanted to serve him at a safe place, and they wanted to serve him where they knew they could serve him. So that was going to be at the Chamblee police station. And I waited inside, and we actually communicated, and he saw Investigator Jones come, and he left the parking lot, and it was witnessed by him. After that happened, my son, he doesn't want to have to be worried about his dad being incoherent and not being able to take him to school or take him to his activities. He's scared of him when he's like that.
Let me interrupt you again. Was your son with you at that Chamblee police station exchange?
Not that time, because the investigator told me he was going to serve him and I didn't want him served in front. So he would have come. If he was going to go with him, he would have met us up there. But the first time the investigator said not to bring him up there.
All right. Were there any other attempts to comply with Judge Adams' order?
Yes. And his sister was the
Okay. So the people have spoken. We are gonna go. So this is what I'm gonna do. I know you want closure on this. So this is what I'm gonna do. We're gonna go to Judge Puff Webster now and her beautiful glasses and this moron in small claims court. And then what I will do is I will stream part 2 as the end of the live. Okay? So I'll stream part 2 as the end of the live. And then, so for you who want closure, I'll run it for you, and then I'll end the stream. So let's get to Webster. So basically, we're killing 2 pigeons with 1 stone. Okay, here we go. I promise that won't happen a lot. I promise. All right, here we go. So Judge Webster, this guy made an appearance once before. It was to set up his court date, and I don't know if he's in the library or the Kansas, whatever, and he doesn't have internet access. He lives in the woods, and he is a card. His name is Mr. Mock. Well, let's roll. Enough said. Okay, we can end the stream now. Here we go, Judge Puff, baby. The people have spoken. So this is a insurance claim. This is insurance claim. He's claiming that he's paid or he wasn't billed. I was working. I didn't really hear what was going on, but it's about insurance claims that he doesn't think he's responsible for, and Judge Webster has to make a ruling. We get closure on this one too. All right, here we go.
We'll start shortly. We're having some technical difficulties this morning.
Webster. She likes to build the suspense before she comes on. She's like Elvis. She has her handkerchief on. She has somebody tying it for her. She puts the frames on. She's like, let's rock. She puts her robe on. Missy, are you ready to rock? And now, out of the 13th district, your friend and mine, Judge Phyllis Webster. Webster.
Insurance, which time the court denied a motion for summary judgment, finding that there were some issues of fact that need to be tried. One was that the defendant was arguing some bills were not his, that some of the bills had been paid and others could be paid by his insurance. The parties were going to compare, I think, notes and see what they came up with on their own. So we continued the matter for another pretrial today. And Ms. Ely, have you been able to get together on this and sort through things to see if there are any issues?
Your Honor, the parties have not spoken since the last hearing. I did reach out to the provider. I got the explanation of benefits from the insurance submittals. I also got a copy of the Blue Cross Blue Shield insurance card. I think there was some issues as to whether that was Mr. Mock Jr.'s or his father's. I did confirm that it was actually his, at the time, current spouse's insurance card. I also did get some consents to treat that were signed by the defendant, which supports that, the services were provided to the defendant instead of his father. I resent out discovery requests as the court ordered, as well as copies of the explanation of benefits, the insurance card, and
yes, Robert,
and a cover letter letting Mr. Mock Jr. know basically what I have discovered since our last hearing. But since then, I haven't heard any reply and I haven't received answers to discovery either.
So, Mr. Mock, it sounds like Miss Ely has been very busy and diligent tracking down the allegations you made, but you didn't seem to do anything. What have you done? What have you done? You didn't call her? You didn't give her any information?
I didn't realize that's what I had to do.
Okay.
I've been investigating on my own.
Well, that's fine. What have you found out?
I talked to Ashley. She's a representative for Aetna, I think it is.
Okay.
And they went ahead and they're going to do a whole new reevaluation of what claims got paid, how much they got paid, who authorized it, and how this, what do you call these validations? Is that right?
Are you talking about the interrogatories?
Bills, yeah.
Are you talking about the questions that were sent to you by Miss Ely?
Yeah, they're up front, and then behind that is the actual bills.
Okay, but you didn't respond to Miss Ely's question she sent you?
Miss Ely, I apologize if you did ask me to do that. I didn't write it down, and if I didn't write it down.
Is it attached to the papers you're holding up? Are her questions attached to that? Is your request for discovery attached to that, Miss Ely?
I believe so, Your Honor.
Everything's on here. Nothing's been tore off.
Okay, so you didn't answer those
That's the best answer I can give you. You'll have to describe it to me or tell me what page it is. If you will.
Well, okay. Doesn't the top of your paper say something like interrogatories or discovery, that first page in addition to the cover page? Hold up what you have there in front of you. Hold up the front page. Okay. All right, request for admissions. And then what's the first question or first statement? Do you need some help reading it?
I did not bring my glasses.
Okay. All right, well, that's what we're talking about. You probably need the assistance of your glasses or someone to help you through that. Because usually when you don't answer those, it goes against you. You're required to provide the information there that she requested.
I'm not sure.
All right, well, so the only thing that you can tell me, Mr. Mock, is that you went back to Aetna Insurance, which would have been what, the one you had when you worked for the state, for the Department of Corrections?
No, ma'am, I've never possessed any other insurance other than Medicare since I was probably about 2006 is when that started. Kelly Johnston law offices got that approved for me. And my wife at the time, she, they periodically change hands, their interests change hands.
Oh, okay.
So she knew, and I've been very adamant about relaying that I do not want secondary insurances from her work. It completely messes up how Medicare does business and the doctors I see.
All right, oh, I'm sorry, go ahead. I don't want to cut you short.
Miss Ashley was kind enough to send me an email stating that they're going to go ahead and do a full review on the billing, everything involved that is questionable.
And you said Miss Ashley is with which company?
The Aetna thing, Athena.
Aetna Insurance. And when did you have Aetna coverage?
I didn't know I ever had it.
You're the one that keeps bringing it up. I don't understand. Why do you keep bringing it up if you never had it? Why would they do a complete background review if they never had you on their insurance?
I didn't know about that.
How are they connected or relevant here?
They're on the bill, they're on the statement. Some of these other, the two other companies also denied service or have me pay deductible. And I didn't even know I had those cards were on my billing.
Okay, let me go back to Miss Ely. Miss Ely, can you make any connection or sense of what he's trying to tell me here about Aetna? How are they involved?
From my understanding, Your Honor, there was some Aetna insurance at some time provided to Greenwood County Hospital, which is the provider for all the services that are contained in this lawsuit. 6 of those, of the 7 that are concerned in this lawsuit, it looks like Aetna was billed to, but they did not pay. Although Medicare did pay, Aetna did not because it was applied to the patient's deductible.
Yeah, well, this is going to affect all of the insurance so-called providers that are on there. The only one that I authorized to be used was Medicare. Now the other ones got put on there, I do not know. This is her email.
All right.
How do I get it?
Well, let me read that. Good afternoon, Mr. Milton. Hold it still, I can't read it. Good afternoon, Mr. Milton called in that's Anthem today, informed us that he had Medicare. We were unaware. And today I updated his coordination of benefits. It can take up to 30 business days to determine the change. Any questions I can be reached at, and then she gives her number and extension. So that's, can you drop that down a little bit? So Anthem must be the Medicare provider, Miss Ely.
Your Honor, from my understanding, from what the provider has told me, is that Anthem is a Blue Cross Blue Shield company, which Blue Cross Blue Shield was provided for one of the dates of service here. And they did, it looks like it was a copay, which is what was left. Otherwise, Blue Cross Blue Shield or Anthem did make payment on that. That insurance is his ex-spouse's insurance.
So are some of these bills for him personally, or the services they covered, except for $25 that you owe? Right. So what about the rest of these bills? What's your position on that, Mr. Mock? She's checked them out. They're not your dad's services. They're not your wife's services. They're your services. And part of them have been paid by your Medicare and your insurance, but then there's still some apparently that haven't been. That's what she's saying. What are you saying?
I'm saying in my medical files, my medical records, and I talked to the ladies up there last night again about it. They're trying
where, the hospital?
They're trying to check at the hospital, billings and records. They're trying to track down the affidavits that I wrote about this is the insurance that I want to use. There is no secondary insurance. I don't want to use my wife's.
Okay, nobody's trying to make you use your wife's. Miss Ely, did I hear you say you had the affidavits or the information showing that he had received?
Of the 4 of the 7 accounts that are at issue, I do have consents to treat or admission agreements for 4 of them. The other 3, they don't do those for clinic visits.
It surprises me. I didn't know that any medical provider didn't make you sign a form committing to payment. But you're saying the clinic doesn't make him do that every time he goes in?
They don't have those, Your Honor. They don't have those.
But they do show that he went in and he received the service.
They do. They have confirmed that the services were provided to Mr. Mock Jr., not Mr. Mock Sr. And in Medicare, again, Medicare came through and paid on all of them, besides the one that was submitted to Aetna or Blue Cross, to Anthem or Blue
Insurance. It covered him, maybe potentially, but he didn't want to be involved in it. So, okay. So, Mr. Mock, it sounds like she's ready to go to trial if she needs to. She's got documentation to have those services, and you don't need to pay for them. But what she's telling me is she's gone back and researched and confirmed in her mind and in her notes and records and files that it was you and that you do owe it. So, but
have you been able to, Ms. Ely, been able to put a calculator on those figures? Because there's some discrepancies, overpays.
I guess I don't understand the question. I don't see any overpays on my end.
If you add each section up, some of them are, one of these days I'll be paying this stuff.
Okay, so you have some questions about how that statement reads?
No, it's the math. The math is wrong on enough of them that it's concerning. And that's why Ashley B at Anthem, whatever it is, has gone ahead and they're going to do a full review of what got paid, how much got paid, and she said it could take up to 30 days to get it applied back. I assume, since if anything changes with that, all the Medicare that went before that will have to be gone through again too, because they were, again, against my wishes, put on as billing parties.
On data service.
Well, it also, there was a one on here that Medicare was not even a factor for processing the bill.
Well, it sounds, Mr. Mock, like we're all trying real hard to resolve this, but I don't think it's gonna happen short of just putting the evidence on. I can give you folks more time to try to talk, but I'd hoped you would do that by now, and that didn't happen.
I apologize. I was unaware that.
Well, she sent you the paperwork. Did she give you a number you could call back on that paperwork?
That's your place of work cover sheet.
Was there not a cover sheet on it? I thought she said there was.
I thought there was too, man. Got weird.
Okay. So, Ms. Ely, do you want to just set this for trial, or do you want to try to, I can even let you go in a breakout room right now if you think it would do any good.
Your Honor, I think we probably need to set the matter for trial at this point. I would request, though, that, the defendant answer our discovery requests. They've been sent out twice, and I still haven't received any answers to those.
And if you haven't answered those at the time we go to trial, I think that's basically an admission on your part, sir. I think you told me last time you were on full disability.
So I'm wondering, how would you get your money? I don't have any extra. I'm just barely getting by as it is, and that's with the help of a lot of good people.
Well, I'm not here to determine how they're going to, I'm not here at this point to determine how they would collect if they got a judgment, just to determine whether they're entitled to a judgment. We will set this for trial, and then if you guys can work anything out between now and then, so be it. Missy, what do we have for a trial date, an evidentiary trial date?
Do you want to go out like 30 days?
And you think an hour will do the trial, or do you wish more or less?
I think an hour is just fine.
So, Missy, what do you have, about 60?
How about June 1st at 10?
That will work for the plaintiff.
Okay, Mr. Mock, we need you to be back here June 1st at 10 a.m. for your trial. You'll both have an opportunity to put on any evidence that you want. If you, Mr. Mock, have any documents that you're going to want to present, bring those up to Missy about a week in advance and get a copy to Miss Ely as well. And then before I let you go, I'd like you both to go into a private conference off of YouTube and make sure that you can have it. Okay, well, I think you can just, if we just quit recording and go off of YouTube, you can just talk, just exchange any information that you possibly can. I'll just leave the hearing, and Missy, that'll work, won't it? If I just leave, if you.
Told you that was a doozy. I don't disappoint. I told you that was a doozy. Let's give another one. We got too many people in this room.
What you want your name to be after this name change. And then you sign at the bottom of it, and there should be a space for the judge to sign, and you'll file that with the clerk, and they'll give it to me to sign, okay? And that'll accomplish, you don't have to come back to court, but you do have to file it with the clerk. Okay? You do that, and I'll sign it, and I'll change your name to whatever you want. It doesn't have to be that. It could be anything you want it to be. If you want to change your name to Taylor Swift, I'll do that.
Here we go. You know it's not alive without Judge Dad.
Provide proof of completing 16 hours community service. That was supposed to be done by.
And I swear, it's like these judges knew the theme tonight was going to be crying. We have one crybaby after another. This one is an extreme crybaby.
December 20 of 22. How is she going to proceed here?
Guilty with explanation, Your Honor, and it is completed, and I did put the
All right.
the documentation.
We'll talk about that momentarily. Ma'am, if you plead guilty here, I want you to understand this would be deemed a technical violation, and this would be the first on this case, and you could get 5 days. That's new legislation. Do you understand that?
Well, I don't
I just want to know
understand
if you understand it.
I don't understand it. I
Okay,
don't
then
understand this whole thing,
All right, slow
because
down.
I don't understand why
Slow
I
down.
violated.
Now, don't get angry with me. I didn't do anything.
We have an explanation.
Hang on a sec.
We have an explanation.
I'll listen to the explanation. I told you to have the community service done by December 20th. The charge is that you failed to provide proof of completion of your community service by that date. That's all I'm telling you. The maximum you could receive on a first technical violation is 5 days. Do you understand that?
I understand what you're saying, yeah.
All right. Did you sign, read, and understand the advice of rights form? This yellow advice of rights?
Yeah.
If you plead guilty, you will be giving up all of those rights and there will not be a hearing. Do you understand that?
He's just reciting the document that you signed.
I'm just having some problems with that.
We're gonna get to that, but he's got to tell you what your rights are because that's his obligation as a judge. He's just letting you know what the maximums are and what your rights are and that you received the notice.
Yeah, I received that.
So do you understand what I've said?
That if I sign,
No, I said, did you sign?
I did sign it.
Did you read it?
I did read it once. Takes me about 3 times.
Okay.
But
Well, slow down, just slow down. Did you understand it?
through his explanation of it, okay? And he's telling me that it's just,
Hang on. I don't want to know what your lawyer's telling you. If you plead guilty, you're giving up your right to a contested hearing. You're giving up your right to question their witnesses, to question Ms. Wild, to bring in your own witnesses, to use the subpoena powers of the court to bring in those white witnesses. Why are you shaking your head?
I don't want to plead guilty because that wasn't the
Ma'am,
communication that we had.
Ma'am,
I understand that
Ma'am.
you said,
well, I told you to have it done by December 20th.
right,
This is March,
right,
back on the tail end of March.
right.
And in fact, the form that was handed up says the hours weren't worked until March 19th. I'm not going to make a federal case of this. I don't want to argue with you.
Me either.
We're going to go through the process. If you want to have a hearing, she's going to testify as to whether or not she provided proof of completion by December 20 of 22.
No, I did not.
Okay, so we don't need to belabor this. Okay? All right. Nobody here is your enemy. Nobody here is your enemy. They have instructions from me. I sent you this November 10th. I didn't think it was unreasonable to ask you to have 16 hours done within 40 days. Maybe other things came up, I understand, more than you think. But let's get through the process. If you want a hearing, I'll swear her in. If you don't, if you want to plead guilty, I'm going to take your plea. I'm going to listen to what you have to say. I'm going to listen to what she has to say, what your lawyer has to say, and then I'm going to sentence. Okay? Fair enough? Fair enough?
Yeah.
All right. Your name?
Elizabeth Watts, probation.
So do you want to plead guilty?
With explanation.
With explanation.
All right. You understand all your rights?
We're being recorded, so we have to have an audible sound.
Do you understand all your rights?
Yes.
All right. If you plead guilty, you're giving up those rights. Do you understand that?
A minute, okay?
To the charge that you failed to provide proof of completing 16 hours community service by December 20. How do you
Yes.
plead? How do you
Guilty.
plead? Did you fail to provide proof of completing your 16 hours community service by then?
No,
No, I'm asking, did you provide proof of completion of community service by December 20 of
No.
22?
I did not provide.
All right, anybody force you to plead guilty?
No.
All right, please accept it. What do you want to say? What's it?
Your Honor, in speaking with my client in private, she had exercised diligent efforts to get the volunteer work completed by this time. It was spotty. She wasn't getting maybe 2 or 3 hours here and there. My understanding is she reached out to Ms. Wilds. There was a Victory Gym. She was only able to get 2 hours a day. And she was just having trouble finding places that would afford her an opportunity to do the community service within a timely fashion. So she actually had to do 3 days at Victory Gym to total the 6 hours. Is that correct?
Where was this community service that she has provided proof of? Where was this completed?
My church. The last 10. I did 6 at Victory. I did 2 at it was Miss Wilder's referrals. I went through Miss Wilder's referrals first.
It just doesn't tell me that it was at the church. I don't see anything on here that says.
That was at Victory, correct?
No, that's South Point Church.
Okay.
That's South Point Church.
Okay, you have southpointcc.com. Can you hand that to Beth, please? Ms. Wilds, I'm gonna hand you that.
So she's trying to find volunteer organizations that can provide her with the work that she needs to do to get it done. And she was struggling trying to get enough time in. So we're just asking, Judge, we're asking not to revoke her. She's got 1 more anger management meeting. And then I think she's completed all of her terms and conditions of probation other than finishing out. And I think it starts 9 months. It started on November 22nd.
Let's just talk about this right now.
Thank you. It's completed.
I know, but she did it 3 months late.
She was struggling trying to get volunteer organizations.
Judge, I went to Mims' place.
What's Mims?
Whatever her referral place is.
What's Mims?
It's down the street, Your Honor. They help veteran families.
That would have been a nice place to
They
do it.
weren't doing anything until after the new year, and then there was nothing there. I went to Fish and Loaves. It was in the middle of winter. It was cold. They were still locking the doors and not allowing me, not allowing any volunteer come back. I work 5 days a week. I get up at early in the morning, and I get home in time to give my son some dinner. So that played a part of saying, I've got to do it after work.
All right,
or I've got to do it on the weekend.
All right, just calm down a little bit.
So then I went to Victory
Can I ask
Gym.
you a question? Are you? I've always been fair with you, Ms. Caballero, but when we have these encounters, you just seem angry.
I am. I'm very angry at the system and what has happened to my son and how the police have treated me in the whole process of my son's. And I'm 53 years old now. I have sat and watched and been involved in enough to know that this isn't right, this is lawless collusion and back scratching. And as soon as you have, you believe that it's not being handled right and that there's no accountability for these officers that are lawless and doing things lawlessly, then you get the retaliation of speaking your truth.
Wait a second. Let's back up.
My son is dead.
I'm sorry.
It's been 6 months.
I'm sorry about that. I really am. I truly.
So that's.
Wait a minute. I'm sorry about that. I really am.
I know you are.
and you're the only one
No, wait a minute.
that had enough.
Wait a minute.
Loving Judge Dad moment.
Our system is not perfect. It isn't.
And how fitting.
I'm sorry, listen to me, please listen. There's nothing perfect about this system. I'm not perfect, I make mistakes.
Me either. Me either.
But it's the best in the world.
Yep.
And not only that, I don't care what anybody says, there's no branch of government in this country that can compare with the judicial system, not one. They're not in the same league. We don't have lobbyists. We don't engage in ex parte communications. It's not close. I feel so strongly about it. I really would like you to listen to me. I'm not going to do anything here. I'm not going to do anything. I'm not going to do one thing. I would really like you to go see a counselor.
I am, and that's the one
All right,
thing
listen.
that has come out of this.
Listen.
That Kristen
Listen.
from
Listen.
the prevention service.
Listen. I want you to focus, if you will. And I hope you tell him the judge thinks that you're angry. The judge thinks you're angry. I'm not a psychiatrist, a psychologist. I don't have. Best I can say is one of my two majors was in psychology, but I don't have any delusions of grandeur that I'm an expert in that. But you've just seen angry.
Your Honor.
Ma'am, please listen.
Okay.
I'm never going to say that anybody's always right. The police aren't, the prosecutors aren't, the defense lawyers aren't, the defendants aren't. I'm not, nobody is. But the overwhelming majority of all of those that I just mentioned truly try to do the right thing. They truly try to do the right thing. There's going to be bad apples in every profession. Every single one. I just wish you'd put aside the anger.
I'm doing it. I mean, I'm working on it. It's just, it has not been my experience.
Well, I think you're wrong.
It has not been my experience.
I think you're wrong. I would tell you if I thought differently. I don't always agree with them, and I got to tell you, they disagree with me. From time to time, as does Mr. Baldwin. I'm sure the probation director could tell you sometimes, well, he wasn't tough enough, or whoever else out there.
Yeah.
It's okay.
Yep.
I want you to go get yourself some help.
I
know, but work hard at it. I'm going to let this go. You've been through a lot. I'm going to let it go. I'm not going to extend probation. Is she going to be done with the anger management? When's probation scheduled to end?
Her probation scheduled in August 10th, and she does have one more session of the anger management to do, one more follow-up.
So, and in fact, I believe you're eligible for early discharge. So if you get that anger management done,
Tuesday.
90 days, Your Honor.
well, now 90,
Yeah.
but you get
Why
that
now 90?
because of this.
Yeah.
Because there's a violation.
And that's my.
Well, but wait a
that's my whole
second
thing.
now, wait a minute.
Why was I violated?
Why you were violated is because you took 5 months, 4.5 months to do that, what you were supposed to do in 6 weeks. Listen.
Telling me that.
Listen, I told you that, the sentence document told you that. You knew you had to have it done. I don't want to quarrel with you. I'm bending over backwards for you. I understand what you're going through more than you know. I'm only telling you, it's nobody's fault in this end.
She wasn't telling me I was in
not-
violation.
it's
She
not
was telling
her-
me, get it done.
it's-
Okay,
it's-
okay.
it's-
Try here. Here's another referral.
It's not her fault.
But she wasn't telling me, Bernadette, you are violating. She's saying you got 2 weeks to
waited
get
too
this
long.
done.
Wait a minute, he didn't violate.
Well,
didn't violate.
I accepted the plea. She waited too long, if anything, to file this. She should have done it back in December.
You're not violating her probation today.
Well, I took her plea. That's why she can't get off for 90 days. There's no getting around this.
Okay, Judge.
She didn't do it in time.
I understand.
And I can be compassionate, but you gotta just calm down now and stop blaming everybody else. She did nothing wrong. If she did anything wrong here, she waited too long to generate the show cause. When I say something, I give them leeway, but I expect them to carry out my orders, and she waited another 3 months to generate the show cause. Now listen to me. Stop. You get the anger management done, nobody's going to be bothering you. Ms. Wiles, once she's done with the anger management, you're not gonna see her again on a probation visit, are you?
No, in most cases, we put individuals.
Unless there's some other violation, like a violation of law, you're not gonna have to worry. So let's get past this. I'm letting it go. I'm accepting what you provide. That's it. Thank you very much. I sincerely wish you well, Ms. Caballero.
Just for the record, she can also be discharged early from probation, even after the 90 days, because she's not even off until August anyway.
Yeah.
You're still eligible for early discharge.
Right. She's eligible from the day she gets, actually, at the end of June.
The
At the end of
process
June.
we would have to, there's a victim on the case, we would have to.
I know. But good luck.
You're still
Good luck.
eligible for discharge.
Midland Credit.
He always gets the slow clap. Okay, what I'm going to do is I am going to stream the part 2 of that TPO for everybody so we get closure on it. I'm going to shut the webcam off. I'm going to let you enjoy it. A little old squishy Gardner type. Welcome to my new viewers. Sit back and enjoy. Got 450 in the room, 457. Here we go. Here's tpOMG. Yeah.
Up all of those rights, and there will not be a hearing or a trial of any kind. Do you understand that?
Yes, sir.
All right. To the charge of operating while visibly impaired, how do you plead?
I was like, oh, mute Mr. Branch. You gotta stay. Mine's no. Hang on. I'm gonna send it to you. You're gonna talk to my attorney.
Your Honor, we're all back.
Yeah, we're all back. Okay. All right. All right, Mr. Branch, did you have a chance to send that information to Mr. Roberts?
I did, Your Honor.
All right, and Mr. Roberts, have you had a chance to review the police report?
I got it, Your Honor, and it's the recantation of the things that she mentioned to the court at the beginning that happened in April of 2022, which she.
A supplement to the report, and that's what she had indicated in her testimony. Okay. All right, go ahead, Mr. Branch.
Okay, and so I would like to move on to a new witness now. And so I was going to call Miles Hurst, their son, to testify.
All right, and where is Miles?
He's with Ms. Hurst. I believe he can just jump onto her camera.
Your Honor, before you start, just let me say one thing about Mr. Hurst's sister. She is in the hospital, unfortunately, being treated for a severe form of lung cancer. And she is unfortunately not available as a witness. I do not know if the conclusion of this hearing, it's something that we need to check on to find out if her testimony might help or be of assistance to the court. But I'm letting the court know that that's why she's not here, is because she's in the hospital with cancer.
All right, thank you for that, Mr. Roberts. All right. Ma'am, you can't talk to him while we're about to testify.
Your Honor, could I ask that Ms. Hurst not be present during her son's testimony, out of the room, out of his presence, and not in any way trying to coach him or to signal him or do anything of that nature?
I was going to leave the room.
Yeah, and you're free to log back in on another device, and so that you can see and hear and everything, but we need him to be in the room alone, okay?
Okay, I was going to leave. I'll let him hear and I'll be in the other room.
Thank you.
Thank you.
All right, Mr. Branch, you can go ahead and swear your witness.
Okay. Miles, could you please raise your right hand? Okay, and do you swear and affirm that the testimony you are about to give is the truth under penalty of perjury?
Yes.
All right, thank you. And you can put your hand down. All right, so Miles, I appreciate you hopping on this call with us. I just have a few questions about some of the incidents that may have occurred in the last year or two. So Miles, have you ever had to call the police on your father?
I've asked for my mother to call the police. I haven't personally used the phone to call them, but I have asked.
Okay. And when was the last time that you asked your mother to call the police?
Got this.
And you can give a rough estimate, just
about, I guess about last year or a couple months ago, whenever.
Okay. And why did you ask your mom to call the police?
He was being very loud and violent, and
you're referring to your father?
Yeah.
Okay.
What date are we talking about?
So Miles, you said you asked your mom to call the police. Was this around October of 2022? Does that sound right?
Sounds about right.
Okay. And you said your father was being loud and violent. So could you describe what he was doing that made you want the police called?
Well, my memory's a bit hazy, but he was yelling a lot, and I heard a lot of skedaddling and saw some stuff.
And what kind of things did you see?
Well, I believe I saw him put hands on my mom.
Okay, and where did he put his hands on your mom?
I didn't really see very well, but it was around upper midsection, I guess you could say. I believe.
Okay.
Or in
And
upper.
we're just gonna. I'm just gonna ask you. I'm gonna ask for more details because we want you to be as specific as possible. So, did your father? Did he hit your mom, or was it a push? What kind of action did he take?
Well, it was I wouldn't say it was like a really, really hard punch, but it was a punch, you could say.
And you said to her midsection, so was it her chest, or was it on her arms, or
Like
where?
around here-ish. Like
Okay.
around.
And where were you at the time of that incident?
Well, around my room-ish.
Okay, so you were in your room, and where were your parents at that time?
In the hallway. My room is like in a dining, it's like right, if the dining room's like, it's like across from my room. So yeah, and then the hallway
Your
is
door was open. Am I correct in assuming that?
the what?
Your door was open at that time?
Yeah, like slightly open.
Okay.
A little bit.
And so you asked your mom to call the police, and when did you ask her to do that?
I can't remember exactly.
So was it the same day as the time you saw him hit your mom, or was it after or before?
Same time, yeah.
Around the same time? Okay. And did you ever speak to the police at that point, or when they were called?
Yeah, when they're called, I tried to go back to sleep, which, yeah, I went back to sleep, and I woke up to them at the door or whatever.
Okay, and they asked you questions about what happened?
Yeah.
Okay. And are there any other times that you've asked your mom to call the police on your father?
I believe so. A couple years ago, I would say. It was like quite a few years ago.
Okay, and so what was the reason that you asked your mom to call the police then?
just being loud, if I remember correctly. This was like maybe 6 to 7 years ago.
Okay. So around 2017, 2018, around that time frame?
I guess, yeah, maybe.
Okay. Do you recall if your parents were still married at that time?
I think so. I can't remember exactly.
Okay. And what did your father do at that point? What caused you, as specific as possible, what caused you to want the police?
It was very, very loud.
He's very loud? Okay.
Yeah, which I was very young too, so I didn't know. But
Okay. And in recent, so let's move back to the last year or so, all right? And have you been to see your father in the last year?
yeah, I've been to his house.
Okay. And when was the last time you saw your father?
Let me think about this. About a month or two ago, I think. I can't. I kind of don't have a very good idea of time.
Do you remember what you did with your father that time?
We went to Little White House.
Little White House?
Yeah, Little White House. I can't remember exactly where that is. I know, like, yeah.
And have there been any points where you have not wanted to go visit your father?
Right after the incident, I told him that I didn't want to spend the night because I had plans that night, and didn't want to. And another time, for the same reason.
Okay, and that was around October of 2022?
Yeah. Well, maybe like a month or so after.
Okay, so maybe in November or December?
Yeah.
Okay. And have you ever found anything of your father's that may have given you concern?
Yeah.
Okay. And what did you find that gave you concern?
Alcohol. At like a very long time ago.
Okay. And so that was, you found alcohol a long time ago, and anything else?
I found alcohol recently, kind of, yeah.
Okay. And have you found anything that wasn't alcohol that gave you concern?
I wouldn't say concerned, but not really.
Okay. And so even if it didn't give you concern, what did you find that wasn't alcohol?
Pills, I guess, yeah.
There were pills, and where did you find them?
In the bathroom.
And were they in prescription bottles, or were they in something else?
Some of them were in bottles, some were in bags.
Some were in bags? Okay. And Madam Clerk, could you please share exhibit, I believe it's 20, let me double check. Yes, exhibit 20, I sent that a little bit later.
Okay, 1 moment.
Mr. Banks, Mr. Branch, I'm sorry, while she's doing that, is Sid Hurst your client, maybe under a different phone?
Correct, yes.
Okay, so we need to let the phone Sid Hurst in so that she can be present.
All right. Thank you. And so Miles, is this a photograph of the substance that you found in your father's bathroom?
Yeah.
Okay, and did you take this photo, or do you know who took this photograph?
I did not take this photo.
Okay, and this is an accurate description or an accurate photograph of what you found that day in October?
Yeah.
Okay, and Your Honor, I'd like to introduce Petitioner's Exhibit 20.
Mr. Roberts, any objection?
No, I couldn't quite understand. Did he say he did not take this picture, or he did take this picture?
He did not take this photograph. His mother took this photograph.
Your Honor, I don't think that's the proper foundation. If his mother took the photograph, I don't think he can identify it as an object to be admitted, authenticated.
Well, I'm going to give Mr. Branch a chance to recall anyone before we go through with the admission of this photo. At this point, we don't have it, but I'll give you a chance to clear that up, Mr. Branch.
Understood, that's fine. Okay, so Madam Clerk, you can remove this exhibit from the screen, thank you. All right, and Miles, has your father ever made threats to you or to your about your mother?
To my mother, I'd say so, but never to me. He hasn't hit me or anything.
Okay, and so what kind of threats do you recall your father making against your mother?
That he was going to cut her life insurance off. I remember that one pretty vividly. And stuff about, like, I guess, cutting off appliances and things.
Okay, and has he ever made any other physical threats to her safety or anything like that? Do you recall?
No, not really.
Okay.
Remember, at least.
Okay, understood. And do you feel comfortable driving with your father?
Not,
Guys, just make sure at the conclusion of this video, once you see the outro, make sure to hit the like, subscribe, and head over to Kitchen Court Cases, see what she's cooking up tonight.
not really, like, way back then, but I feel.
Ms. Hurst, you need to stay in one spot, please.
I would say recently I do, but like years and years ago, sometimes I didn't really feel comfortable driving with him.
Okay, understood. I have no further questions. Thank you, Miles.
All right, thank you, Miles. Mr. Roberts, do you have any questions?
Just a few questions, Your Honor, from this young man. Miles, I'm Stephen Roberts. I'm an attorney. I'm just going to ask you a few questions, not a lot. If you have any problem understanding my questions, so let me know and I'll re-ask them, okay?
Okay.
Okay. So this incident that occurred back in, you said October of 2022, I think the police report says it was September 27th or 28th. Is that the incident you're talking about where you said you saw your father's hands up near your mom?
Yeah.
Okay. Do you recall telling when the policeman came the next day from that incident, not that actual day?
Can you say that one more time?
Were you home when the policeman came as a result of that incident?
Was I involved?
Were you at home?
Oh, at
when
home.
The policeman came.
Yeah, I was at home.
Okay. But that was the day after this alleged incident that you saw, correct?
Yeah.
Okay. And was your dad at home when the police came that next day?
He was coming back from McDonald's, I believe.
McDonald's. Okay. So he went to get breakfast, is that right?
Yeah.
Okay. But after that incident, the three of you stayed in the house together that night, right?
Yeah.
Okay. You didn't call the police that day, and your mom didn't call the police that day, correct?
I believe she called the police to make a follow-up report or something, but I'm not exactly sure. I was kind of like just staying in my room the entire day.
Okay. Do you recall telling the police that you didn't actually see the incident, that you were in your room? You just heard it?
I heard it. I said that, but I was very, very tired and very shook from everything.
Yeah. And you said that basically the problem you've had with your dad is that he just gets loud when they argue, correct?
He gets loud, and at that time he did get violent.
At that time? You mean back in September of 2027? I mean 2022?
Yeah, September.
Okay.
Yeah.
All right. But since then, when your dad moved out, you said that you have recently, in recent times, not have any problems riding with him. So is that correct?
Yeah.
Okay, so I can deduce that his conduct, in your estimation, at least as regards to drinking, which was your main concern, that has alleviated, that's gotten better, correct?
Yeah.
Okay. Now, were you aware that the judge had ordered some visitation between your dad and your mom for you to visit between the two of them?
I was aware, but I don't know if I'm aware of the extent of it.
Okay. But you have visited with him at least once since this incident where your dad was arrested on September 28th, right?
Yeah, multiple times.
Okay. And you actually went with him to the Little White House, which is down in southwest Georgia, correct?
Yeah.
Okay, that's down in well, we all know where the Little White House is. You all took a field trip, basically, right?
Yeah.
Okay. Now, are you currently being homeschooled? Have you been homeschooled since you've been back in Atlanta?
Yeah.
Okay. Now, is that your choice or your mother's choice?
That's my choice.
Okay. So you haven't actually been enrolled in a school since you've been back in Atlanta, right?
I don't know if you'd call being like in a homeschool being enrolled, but
No,
yeah.
I mean a school outside your home.
Oh yeah.
You
No,
have not. You have not, right?
No, not this year.
Okay. So have you lived exclusively with your mother since your mother and father were divorced in 2019?
I would say so, yeah.
Okay. So you all were living in Alabama for a time and then you came back. Your mom came back and brought you back and you all moved in with your dad, correct?
Yeah.
Okay. Even though you knew they were divorced, right?
Yeah.
Okay. And they lived together from 2019 until, well, excuse me, when was it that they moved back in together? Do you remember?
I believe towards the end of 2019, I think.
2019. And they cohabited together all the way up until the time as your dad was arrested, correct?
Yeah.
And you said you never personally called the police on your dad. You just were objecting that he got loud when they argued, right? Because that scared you, as it would any child.
Yeah. Okay. Yeah. And I would sometimes tell my mom to call the police, yeah. Which
did your mom ever get loud with your dad?
Yeah, they both were very loud, but
okay. So loud and screaming with each other was not that uncommon in your household, unfortunately, right?
Yeah, it was not
okay.
That.
Now, your dad has got several prescription medications that he takes, but he's also worked full time for the CDC ever since you can remember, right?
Mm-hmm.
And has your mom had a job outside the home since she moved back to Atlanta?
No.
Okay. So you and she are pretty much home there all day, every day?
I used to go to in-person school, but this school year I've started doing online school. But yeah.
And your dad's got a sister and a brother-in-law that he's pretty close with, right?
Yeah.
And what's her name? Kay Spies?
Yeah.
Okay. Now, you enjoy spending time with them at their lake house, don't you? And your dad as well?
Yeah, it's been a little bit since I've been there, but yeah.
Okay. But your mom really doesn't like his sister at all, does she?
No, I don't.
Okay. In fact, she's called her numerous names in your presence, hasn't she?
Yeah, I believe so.
Okay. Now, I believe you testified that since your dad had been arrested and his conduct, at least his conduct that you thought was bad involved alcohol prior to September of 2022, right?
Yeah.
Okay. But since that time, you've seen a marked improvement in his demeanor and everything else, and you don't have any problems being around him, correct?
Yeah, I have no problems being around him.
Okay. Thank you.
Okay.
Okay, and I just have a few more questions. So Miles, you said that you've told your mother to call the police on numerous occasions. Is that right?
A few occasions, not a lot.
Okay, and were those occasions where he was just being loud, or was it something more?
As far as I can remember, before the September, it was just because it's loud. But my memory is pretty good for remembering those occasions because they're very traumatic, I guess you could say.
Understood. And you said you feel comfortable driving with him now. Do you think that your father still drinks?
I don't know. I don't think he does, but I don't know exactly.
Okay. And have you ever found alcohol containers in the home since him leaving?
Or this house or his house?
His house.
No, I have not.
Okay. And that's it, actually. Thank you, Miles.
All right, any recross, Mr. Roberts?
No, Your Honor.
All right, thank you. Miles, thank you very much, sir. You can be excused. You can go ahead and log off. All right, any other witnesses, Mr. Branch?
And yes, can I recall Cynthia Hurst to the stand?
Ms. Hurst, you can go ahead and unmute. You're still under oath.
Okay, can you hear me?
Yes, thank you.
Hi, Ms. Hurst. So I want to ask you a few more questions about the incident on 9/27/2022. Okay, and so you called the police the day after that incident, is that right?
Yes,
And that was at the advice of your son?
we agreed if he were still drinking and belligerent the next day, I would call.
Okay. And Madam Clerk, could you please show Exhibit 7 with the court?
Ms. Broom? Okay.
All right, and now this is the incident report from the October or September 27th incident, is that right?
I can't,
Can we
I
go
think
to,
that's the one from March 10th. Oh, wait,
Well,
yeah, that's 27th.
Okay, and this is your account, or this is the report that you provided, or you provided information for regarding that incident?
Yes.
Okay, and have you made any changes or altered the information that is in this incident report?
Yes, immediately following receiving this report, I did contact the arresting officers to correct some things. I know my son was scared and he just gotten up out of bed. He said he didn't see anything, but he did. It's on video. I had no idea that we could go back in and correct it, as well as add the other. I thought that was one time you get and that's all. The Women's Resource Center gave me the advice to report the other incidents. So it actually happened to be the same arresting officer who came out and had time this time to sit down and go through the evidence with me. And he did see that my son was a witness to it, and he put that down there because it was in the video, as well as documented the timestamps like we were doing. He counted 6 different occasions that there was physical violence on it from those documents or those videos and those, recordings. They weren't, just, text messages. They were actual. So I feel like my word doesn't mean much. So I wanted to make sure I had something that was tangible, that was not something that could be made up. And he counted 6.
Okay, and so that you're referring to the supplemental report that was made on March 10th, is that right?
Yes.
Okay, and that has already been introduced into evidence. So, and this is the initial report that you wrote or that you provided information for. And so, Your Honor, I'd like to introduce exhibit or tender exhibit 7 into evidence.
any objection, Mr. Roberts?
Is this the report you just sent me?
This is the September 28th report.
Oh, I think we're trying the criminal case now, I guess. Okay, no objection, he's already testified to it.
Yeah, okay. It'll be admitted without objection.
Thank you. And
Madam
then,
Clerk, if you could take that down, please.
yeah, and then Madam Clerk, if you could share exhibit 20 now. Now I just have the foundation to get that one in and wrap up.
You said number 20?
Yes.
Okay.
All right. So Ms. Hurst, is your son testified that he found a substance in your in the respondent's bathroom. Is that right?
Yes.
And he showed you where that substance was. Is that right?
Yes.
Okay. And is this a photograph that you took of the drugs that your son found?
Yes.
Okay. And have you when did you take this photograph, do you think?
That had been right around October 1st or 2nd. It was after he was arrested. The deputies did see it when they came back, and they did make note of it, but I took a picture because I didn't know if it was going to be reported or not. I didn't know if that was.
You don't know what's in this bag, though?
We don't know what's in it. I can tell you what I think it is because he had pills out with it all over the place. So there was Adderall, Wellbutrin, and then I don't know if they were part of the other pills that he was getting, not through his doctor. I don't know. I mean, I don't want to guess.
Okay. And so, Your Honor, I'd like to introduce or tender Exhibit 20 into evidence.
All right, Mr. Roberts, any final objections?
Well, Your Honor, my objection is nobody knows what this is. This could be perfectly legal stuff. I mean, it hasn't been tested. If the police thought it was something illegal, they would have seized it and tested it. Apparently they didn't. It's hard to believe somebody would leave a spoon like that right next to it that wasn't staged. So whatever the court decides.
Well, I'll sustain it as to any allegation that it is a specific substance because there is absolutely no proof of that. I am going to admit it for the demonstrative purpose of what was seen on the counter. She's given testimony, he's given testimony. So for that purpose, I will let it come into evidence.
Understood, Your Honor. Thank you. Okay, Ms. Hurst, and I have no further questions for you, so thank you.
All right, Mr. Roberts, do you have any recross?
Just a couple, Your Honor. Okay, Ms. Hurst, you had testified about some of the financial situations, and just real quickly, it was alleged that you yourself forged $7,200 worth of checks by signing Mr. Hurst's name. Do you recall that allegation, and did you in fact sign his name?
I didn't sign his name.
You didn't forge
I
his
signed my
name?
name. I
It's
signed
in the
my name.
petition. You signed your name to his checking account, right?
Well, it was ours.
Okay. And that was part of the exhibit in his petition that you asked for reconsideration of, which the judge denied already, correct?
Correct.
Okay. And also part of that petition was a picture of a blunt object bruised and cut to his forehead as part of the exhibit. So this conduct between the two of you is not just one way.
That was actually done because I had my son in my arm. I had a right hand, a Yeti cup. He grabbed me and I swung. I didn't aim. I didn't throw it at him. I did it to get him off of me. My son was in my left arm. My cup was in my right. And it made me sick when I saw it, and I called the ambulance immediately. I didn't aim for him. And it makes my knees weak to think I hurt him.
And your son testified that David occasionally drank alcohol back then. Do you drink alcohol?
No.
You don't drink at all?
No.
You take any medications for any of your mental conditions? No. Okay. And just to clarify, you have or have not had this psychological evaluation Judge Adams ordered?
I've had, not the one. I've had one done, and I've got to do his from his specific. But yes, I've had it done.
When did you have it done?
In December, because he had told me it was something that he'd already threatened to do. So I went ahead and did it ahead of time.
No, I'm talking about the one he ordered on
No,
February 12th.
no, I am doing that. I just have not been able to, but I did submit the other one to to Judge Adams. And it was to also make sure there's no medications I'm on, nothing like that. But yes, I still have to do that. But the thing is paying for that is secondary to trying to move and trying to maintain. I mean, it's not that I'm not doing it, it's just I've got to wait until I can afford it.
That's all I have.
Okay, and I just have a few final.
Okay,
thoughts.
let's wrap it up. Come on.
I understood. Ms. Hurst, the photograph that opposing counsel was just referring to, when was that injury? When did that injury take place?
2008.
Okay, and you did not forge the respondent's signature on those checks, is that right?
Correct.
Okay, what name did you sign on those?
Sid Hurst.
And those were because it was a joint bank account?
Mm-hmm.
Okay, thank you. No further questions.
Just one quick question, John. And with regard to his getting a TPO against you, part of it was based on the 20-something pages of text that you sent him at his work address that you've been ordered to quit doing, correct?
I object, Your Honor. The basis for the TPO is because she did not appear to litigate the case.
May be, Your Honor, but.
I'm sorry, the basis of the TPO is because she didn't appear?
That, I believe, she did not appear for the hearing. There was an ex parte hearing and that evidence was considered, but we have not had a chance to actually go through each of that evidence and rebut the claims.
Okay, all right.
That's
We're gonna
fine.
cut it off there.
That's fine.
Okay, do you have any other witnesses, Mr. Branch?
No, I don't, Your Honor.
Okay, thank you very much. Mr. Roberts, you are free to call your first witness, sir.
Your Honor, in our due to the pending litigation with regard to the criminal case and with everything we've heard today and the unavailability of the defendant's sister case spas because of cancer treatment, I'm not going to call any witnesses. I'll just rely on the testimony and the cross-examination.
All right. All right, so at this time, I have heard testimony from the petitioner, respondents electing to not testify, protecting his Fifth Amendment right based on the pending criminal charges.
Yes, ma'am.
I'd like to go ahead and hear closing. Mr. Branch, do you want to open and close, or how do you want to?
I would defer to let Mr. Roberts open and I'll close.
Okay, we'll do that then. Mr. Roberts, you can go ahead, sir.
Thank you, Your Honor. So, Your Honor, basically, I think what we're seeing here is Mr. Hurst was arrested on September 28th, and part of his bond was to have no violent contact, no contact with Ms. Hurst, except for in necessity of exercising his rights to visitation. He has scrupulously done all of that, Your Honor. He has maintained his employment. He has moved out of the house. He had his furniture and things taken out of the house prior to this incident that Mr. Hurst is complaining about now. Under court order with a deputy present, he had his own personal belongings taken out. She stayed in the house until he stayed on the lease until the lease was expiring at the end of October, at which point it became an issue between Ms. Hurst and the leasing agent, and she was ordered to vacate the house. She's now trying to lay that on Mr. Hurst because the owner of the property wants her out because he got a valid eviction order for her. So all of these things, Judge, are tangential to what she's asking for. I'm not really sure what we're here for because basically they just need to leave each other alone except for the exercise of the visitation of the child. Mr. Hurst has done that, Your Honor. Mrs. Hurst is unfortunately trying to use the ex parte TPOs to supersede a valid Superior Court order regarding all of the defendant's financial obligations, which are only to pay child support. And also, he has no obligation to maintain a residence for her. She was living comfortably with her parents in Birmingham before Mr. Hurst graciously allowed her to move back in. She had no problems living with him and letting him pay all of the expenses, of the household expenses, be the only person working in the house, and didn't think that anything was amiss until September the 27th, when she called the police on him the next day following an incident that supposedly occurred on September the 27th. So since that time, she has filed 5 TPOs herself, each time nuancing a little bit the allegations, but almost always referring back to the alleged incident on September the 27th. If all of these incidents that occurred prior to that were so egregious, why didn't she think to mention it when the policeman was standing in her living room on September the 28th when she made the initial police report? It's only because she's upset with her financial situation and the situation that Mr. Hurst is now exercising his parental rights, that she is ignoring, that she has tried to use this to squeeze him financially so that she doesn't have to work or provide anything for the household. And maybe she's not capable of working. Maybe that's why Judge Adams ordered her to be evaluated. She is in complete contempt of Judge Adams. I've not known him to be a judge that would unfairly rule against somebody. She participated in both of the hearings in front of Judge Adams, once with an attorney, once pro se, and he found her to be in willful contempt. The second time, she has still to this day refused to abide by his orders, either to get evaluated herself, which she obviously needs to be, or to make Mr. Hurst the primary custodian based on everything that he heard over 2 different hearings. So, Your Honor, I don't know what she's asking for. Mr. Hurst is more than happy to not have any contact with her. She needs to abide by the TPO that's been granted against her from these harassing texts that she sends Mr. Hurst daily, and also from squeezing him financially and then threatening additional court actions and arrests if he doesn't do what she asks for her financially, which he is under no court order to do. So I would ask you, the court, to dismiss her petition with prejudice. This is the 5th one she's filed. She's finally got her full hearing. I think the court has heard from her. Her testimony is as fluid as, water pouring out of a hose pipe, and it just suits her current needs and her current purposes. We have no problems with Mr. Hurst being under the previous order from the judge on his bond, which is to have no violent contact with her, which he has had none. And also, she's made a lot of references to things that her son was supposedly afraid of Mr. Hurst, that didn't want to be around him, was afraid of his driving, that he was dangerous. He didn't say anything like that. He said that he was not at all afraid to ride with his dad. Years ago, the worst he could say is that his dad was loud when they got into arguments. And the only incident of any consequence that involved any kind of alleged violence, he's been arrested for and is awaiting his court hearing on that. And that's what we're doing here. We're pre-trying the criminal case, at the same time trying to let her nuance and wedge the court to get financial concessions for Mr. Hurst that he's under no obligations to provide. And that's why she is continually refiling these every 30-day petitions. So I'd ask the court to dismiss her petition with prejudice and to allow the current order, that's basically a dual order for them to stay away from each other, to remain in effect, as the court's already said it's going to do. But they just need to quit fighting, Your Honor, and look out for the best interest of this child. Mr. Hurst is perfectly willing to do that, Your Honor.
Mr. Roberts, let me ask you this. Are you representing him on his criminal case?
Yes.
What is the current, what is he currently charged with?
1 count of battery in misdemeanor state court.
Okay. And what's the status of that case?
God knows. It's just over there. Everybody's, 6 months behind in their cases over there.
So at this point, it's just pending.
It hasn't been accused. It hasn't been accused yet, Your Honor.
I see. That's what I was wondering. Okay, thank you.
Thank you.
All right, Mr. Branch.
Yes, Your Honor. And I think my first point is what you were just alluding to, is that the status of the criminal case is still up in the air. We don't know where it's going to go. And as you know, that these cases get dropped all the time for lack of sufficient evidence that can't meet a certain standard. This is for the protection of her and her son moving forward, that is out of the hands of the state, from them potentially dropping the case because they do not see that they have the time or resources to pursue it. This is her decision that she wants to file. The opposing counsel mentioned correctly that she has filed 5 petitions, but that's not for lack of trying. Immediately after the initial incident, or the most significant incident that we've discussed all day, on September 27th, she has filed repeated TPOs in order to get, but has been unable to have the respondent served. Not until we enlisted a private servicer last week were we able to have him served, where he was able to retain an attorney and have this hearing now. So it is not because she is being vindictive and she just wants to play the system. She's been trying to get a TPO for the last 5 months and now is finally able to have her day in court and have these allegations addressed. Now, there has been years of past abuse that she has gone unreported and unmentioned, and she's done this for the sake of her child and making sure he can still have a relationship with his father. But it has reached a point where she can't accept that anymore. And what she needs is a protective order to protect them. And we need the respondent to go through the family violence intervention program to understand that what he's doing is inappropriate and is hurting those around him. So I think the fact that the opposing counsel is saying that she did not mention these allegations on the date of the incident, the most recent police report in Exhibit 7 lists all of the exact allegations that she made the day after, and it even took the persuasion of her son to come to that conclusion because she has gone through this pattern of abuse and letting him get away with it. But that is the point where we've reached today, and we can't allow him to move forward along this path. So all we ask, Your Honor, is that you grant the TPO. My client is doing what she needs to make sure that her and her son are going to be in a good financial position and a living situation down the line. And if anything needs to change through that can be handled by a different court. But the immediate protection is necessary and I think is appropriate under these circumstances.
All right. Thank you all. I appreciate your patience as I heard from the witnesses today and filled in a lot of holes that I had and questions that I had as I was reviewing for today's hearing. This is obviously kind of took a long time to get to this point. As you both have said, it took 5 times, I think, of filing before service was made. But in that interim, approximately 6 months have passed since the allegation of the criminal act, which led to an arrest warrant, and according to Mr. Roberts, and I've heard nothing otherwise, a no contact bond. I've heard no testimony today that there has been any violation of that no contact bond. It sounds like what has occurred between the parties has been communication pursuant to the visitation order on the My Family app or something to that nature. I might not be getting the title right, in an effort to comply with Judge Adams's order that the child be allowed visitation with his father. As it pertains to an act of family violence, I do believe that an act of family violence has been shown. As it pertains to the second element that I have to consider, which is whether or not it is a reasonable likelihood that the act of family violence would continue into the future if this order were not to be kept in place, I don't have that here today. There has been no evidence to support that because he no longer lives in the home. He's under a stay away bond, and there's no reason to believe that any of that at this point is going to change. Now, this in no way prohibits or inhibits Ms. Hurst from filing again. Should something happen and the no bond gets dismissed and he calls her or anything of that nature, that would be outrageous at this point, and he would just be setting himself up for another protective order. So as it relates to today's matter and what's in front of this court at this time, I don't find sufficient evidence to support a 12-month protective order.